Toward west, begin west. To a mid-block cross, baseball. To a bad there and out. And it's, we're doing things to try to figure out differences. One of the most, we asked a couple of important questions. One was, we had an important job or who had direct control. And that's what gets us started today about doing the job. Every person has a job. Every person needs to do their job. Judge McAfee has a job. We have a job. Fish has a job. Everybody has a job to do. Mr. Paul had a job to do with MARTA in dealing with their rules, regulations. Not just because he was doing any job. He was driving a 30,000-pound bus. There was rules and regulations that he needed to follow because it was criminal. And here's what we know that can happen. Special driver doesn't follow the rules and policies. Unfortunately, he is right. So we know that MARTA had safety rule number 1. Professional, press that word, not amateur. Professional bus drivers must. In society, we use different words. Must follows MARTA's training and policies when driving a bus. That's easy. Let's look at another rule that MARTA has. Professional, again, let's stress the word professional bus drivers must take reasonable action to avoid a collision. Early in this trial, Mr. Williams, we do go way back. We've known each other since Pee-wee football days. So it has been my honor and pleasure to try this case with him. He said some things in opening. And the thing that we have to be careful about in opening is, even though the judge will instruct you that it's not evidence, we said some things. We said some things to you. And we asked you to pay attention to those things. Now it is time to see if the things that we said in the opening, if they line up all the way across. And here's how we can do that. We can do that by looking at Mr. Paul's action. And it's not difficult to see what the first issue in this case is. Did Mr. Paul use reasonable, we use that word a lot, reasonable actions to avoid the collision with Ms. White? We heard a lot of red herrings, different deceptive illustrations, unfounded opinions. But all of this leads to whether or not Mr. Paul's actions were reasonable. Remember his actions on June 30th, 2019. Luckily, it's not hard for us to say whether or not they were reasonable or unreasonable. Mr. Williams talked about at the beginning of the trial, opening statement about the burden of proof. We embrace, we have that burden of proof. And here's where it's different. Criminal cases, beyond reasonable doubt. It's not a criminal case, civil case. Civil case, it is for us to prove that these actions be burden of proof. It's simply required that we say more likely than not. More likely, that's important. More likely than not. We talked about the scales of justice. Let's tip it a little bit. Talked about the football field, go down. Even their cross, 50 yards. Not getting into the end zone, not getting into the 30, 40, getting it across the 50 yards. There are some things that we know that we know, and the judge is going to talk to you about this. The plaintiff must prove every essential part of his claim by preponderance of the evidence. This is sometimes called the burden of proof. Hundreds of the evidence simply means an amount of evidence that is enough to persuade you that the plaintiff claim is more likely true than not. And we feel by the evidence that we put up that Mr. Paul's action was the primary cause of this situation. And he did not do his job per MARTA or the CDL rules and regulations. Let's look and see. Again, I talked about Mr. Williams. Before trial, he came in and said, Mr. Paul admits required to follow MARTA's training. He admits required to follow MARTA's policies. Admits required to follow the Georgia CDL manual. Admits required to follow the Georgia law. Admits he was required to wear his glasses per his license and the law, and admits he violated Georgia law and MARTA's policy by not wearing his glasses on that dreaded June 30th, 2019 day. That's what Mr. Williams said before trial. Openly said this, not evidence. But let's keep going. Now, we know of all of Mr. Paul's wrongdoing. Here's how we know about his wrongdoings. He got up on the stand, wanted to tell the truth, and this is what he told us. This is what Mr. Paul came out of his mouth. I was wrong not to wear my glasses. I was wrong not to keep two hands, 9 and 3, on the steering wheel. I did not scan ahead and look both with my head and eyes. We heard testimony that he was scanning with his eyes, but it's scanning. Was wrong not to drive defensively, and this is per MARTA's policies. So want to be clear on that. And was wrong to drive the bus distracted per MARTA's policies. Again, not our words, out of Mr. Paul's word on the stand. Recall earlier, Mr. Williams, again, he put a lot of pressure on us, but we embraced the term, do your job. And if we do our job, there's no pressure. There was 10 commandments to avoid a pedestrian collision. So we knew starting out that we had number 2, we had number 4, number 5, number 8, and number 2. These were the actions that Mr. Paul was needed to take in order to avoid this collision. We knew that before the trial started. So now, as we proceeded through the trial, we know, and we did orange for MARTA, that we could complete the chart. Remember, didn't move anything away, we just added to it. Now it's number 1, stay alert and stay focused. Number 2, do not drive distracted or blind. 3, no tunnel vision, constant stare. You saw the video, no tunnel vision, constant stare. We knew about this. The video is clear. No 2 hands on the road. Scan ahead. Rock and roll technique. Look 12 to 15 seconds ahead. Drive defensively. We got all of those. Here's what's interesting about this as you look at it. We only needed 1. Just 1 of them. We got all 10. We only needed 1 of those. Let that sink in. We only needed 1 of those. We have all 10. Either through Mr. Paul or through MARTA. Period. So once we figure out Mr. Paul's act, we need to now see what was the primary cause of this accident. What was the primary cause of the accident that happened? And let us be clear. We knew Miss White was a mid-block crosser. We never came in here and said, oh, she was at the crosswalk. No, we knew from the very beginning And the defense will tell you it was negligence per se. Judge will instruct you on that. We embraced that. We knew it. We knew it. But here is what's very interesting about that. MARTA knew it too. They trained their drivers to deal with pedestrians in the crossways. Do your job. Do your job. And nobody would say that a mid-block crossing would lead to death. A mid-block crossing is equivalent to death. So let's see what our experts had to say. We had 4 experts. Mr. Cafis, Mr. Grill, Mr. Walsh, Mr. Rodder. There may be some mention about how much we paid them, if we paid them, what they made. Okay, nobody works for free. Our issue was we're dealing with making sure we embrace the burden. The burden is ours. So if we don't come in here and say, hey, this is what we have. We don't get a second bite of that. This is what we have. What did our experts say? We didn't bring them in here to just talk about other CrowdStrike and whether or not the airport went down. We brought them in here to talk about, does the video show what Mr. Polk actually saw? It does not. Ms. White could be seen from 200 feet away. I'm not a distance guy, but just so, again, sports, that's 2/3 of a football field. 50-yard line and on to the other side. That's how far our expert said she could be seen. Then finally, Mr. Polk had time to brake and to avoid a swerve and miss her. We heard Mr. Cafis say, video is not what he saw. Showed you examples. And that was important. Heard Mr. Grill talk about the commercial driver, keeping 2 wheels on the steering wheel, being scanning, and the reasons for that. We heard Mr. Walsh say a couple of things. Former police officer, construction accident guy, works both sides, so doesn't have a dog in the fight. What did he say? He said the first time that Mr. Polk perceived or did anything was 0.5 seconds before the accident. 0.5. What's interesting about Mr. Walsh on his cross, Mr. Scarborough said, well, you put 0.5, wasn't it really 0.55? He said, yeah, okay. But what's interesting, when he brought in his expert, he said 0.5 to agree with our expert, that he had 0.5 to be able to stop. But another important thing Mr. Jeff Walsh said, he could have swerved 3 feet to the right. Not tip the bus over, not throw everybody out, swerve 3 feet to the right. 3 rules. Save a life. Save a life. The other thing which was important was that nobody was in the bike. He could just move over to the bike. And Kevin lied about all of the things that go into a person's decision. Also, no, it's plain. One thing that we want jurors now, don't lose your common sense. We all have common sense. Mr. Walsh, even Mr. Grill, Ryder, educators. There, we're going to hear about glare, all of this. Driving, sun is in your eyes, you block it. Sun is in your eyes, you slow down. We ask everybody, who's driven the car? Who's gotten the citation? Who's did this? Who's did this? You're driving, sun is in your eyes, you have a glare, you can't see. You either block it, slow it down, or stop it. You're not professionals. You don't have a CDL. You either block it, slow it down, stop it. You just don't keep going at the same rate of speed and then say, oh, it was a glare in my eye. And you will see that they didn't bring in an accident reconstruction to say otherwise. They didn't bring in a commercial driver to say otherwise. We say, you see the video. You see what's in the video. They will say, well, the video, this. So that's why we had to bring in those experts. So based off of everything we just learned, from MARTA and Mr. Paul, we only have to prove that MARTA bus driver Paul was more likely than not was the primary cause for this incident. So now this brings us to what we talk about as apportionment. Apportionment is fault. Which fault goes to this person? Which fault goes to that person? And let me be clear. I've said this time and time again. We know this wife was committed block cross. We own that. We've accepted our responsibility for that. And I can remember Mr. Scarborough in closing, I think he said, well, we waited 5.5 years for them to accept responsibility. Mr. White is still waiting for MARTA or Mr. Paupers to accept any responsibility. That's why we're here. We're still waiting for them to accept responsibility. So let's look at the apportionment. The judge will charge you on this. If you believe that the plaintiff sustained damages, you must determine the amount of those damages. Do not make any reduction in the amount of damages because of the negligence, if any, of Ms. White. Here we go. Here we go. You must also decide the percentage of fault. If any of all the parties who contributed to the negligence or the injury in this matter, or any person, entity, you can find they did not contribute, or you can give them a number. We give Ms. White 5%. You may want to give her 10%. But what we know is the primary cause of this situation is right over there. Mr. Paul. That's what we know. Now, we determine if the false actions were reasonable. If they were not, or inadequate, or enduring trouble. Now, we need to decide damages. Very tough thing to decide. Damages, this is where it gets, for some lawyers, very quick, because you got to talk about money. There they go, talking about money. The issue with that is we have no other companies. We have no other way to recover. Can't bring back Ms. White. We can't bring her back. So the only way that we allow under the law is to get not yours, that's the law. Do your job. We're doing our job. That's the law. There are several ways that you can determine damages. You have pain and suffering. And one of the most important things is the full value of Miss Priscilla White's life. Her full value of life. The judge will charge you on the full value. He will give you this charge. You will have it. Damages for the full value of life may include the value of Ms. White being alive, being able to enjoy life, living relationship with her family, which she lost by death. In deciding, you are to consider evidence pertaining to her age, health, habits, or methods of living, which is important. These damages are measured from the decedent's, from Ms. White's point of view. There's no recovery for damages, and you can see it. The last and one of the most important things, last sentence of my slide. Let me be clear on my slide. It shall be measured by your enlightened conscience, fair and impartial jury. Do your job. We all have a job. So, I'm sorry. So we know in dealing with her pain and suffering, which is the other, so the other is pain and suffering. Look at that. Pain and suffering is a separate legal item of damages. And the judge will charge you on this. Pain and suffering, including mental suffering. In evaluating Ms. White's pain and suffering, you may consider the following factors. If any is proven at trial: shock, actual pain and suffering, mental anguish. So let's look at this. We know a exhibit was entered that Ms. White was picked up at 2150. She was pronounced dead at 2218. That gives us 68 minutes, 68, 70 minutes. I think the police reporter, it may have been said it happened at 2148, but we'll go with 2150. 70 minutes of pain and suffering. She suffered. We saw the MARTA bus in Mr. Scarborough. They talked about the big exhibit, the big MARTA bus lit up, arms glowing. But we also saw where that windshield was spider web. Impact of this collision, spider web, that 30,000 bus windshield. That impact, spider web, a 30,000-pound vehicle. Talking about pain and suffering. So it comes at full value of Miss Priscilla White. This is where it gets very interesting. And it's interesting in the fact, I don't know if you remember, I said that some of the questions we asked you were easy. Wear your glasses. Yes. Some of the other questions are your supervisor. Final question I bring to you now, we ask you, anybody on the panel of a broken relationship? Anybody on the panel has not talked to them again, not done this, not we hope, we prod, we ask. We're trying to figure out certain. So Ms. White, you know, at the time of the incident, she was 64. She had 5 kids. She had Mr. White, got pregnant with him at 14, said she was delivered him at 15. He was 15 years, had 5 siblings. He was 16 years older than his other siblings. So she had 8 brothers and sisters. Grandkids. Here's where it gets interesting. We start, and the issue, it gets interesting because when we start thinking about the value of Miss White's life, did she live in Buckhead? No. She lived in Banks? No. Where was she born? Why did she do this? She was living her best life. It had value. It may not be that I'm accustomed to nice watch, good shoes. I have my keys. Brother Andre, get up here. Mama touched me on the face. How proud she was. She loved him. Best friend raised him. Love has value. Type of value that we'll go out and pay somebody, hit a baseball, hit a basketball, because we see that as the value that we get, the value of her life. What did she consider value of her kids, her family? Midlock crossing. That was everybody. So, the judge instructed you earlier that the burden was ours. I will sit down. Mr. Scarborough will get up. He will say some things. He will comment on some things. And we just ask you, we think the things that we started this trial out by saying, throughout the trial, we stayed the course. We swerved, which Mr. Paul would have done. We didn't have to stop, which we wish Mr. Paul would have done. Hell, slow down, which we wish Mr. Paul. And the reason why those are tied together was the primary cause. Mr. Paul not wearing his glasses. A restriction on his license. We'll get up in here testimony about 2030. The restriction was do your job, follow what you're told to do, correct? So, thank you for your time, for your patience, for your attention, for your service. Thank you.
I'm sorry. Oh, good. I need a minute to set up. Jeff, is it okay if I flip it first? I'm here for you to do it.
Is that charging? Is that charging? This is before. All right, Mr. Scarborough, whenever you're ready.
Thank you, Your Honor. Good morning, ladies and gentlemen of the jury. At the beginning of this case, I told you that the defense was going to make efficient use of your time. And I think you've seen that from us. Yesterday afternoon, we hurried through our case so that you would be here this morning, get the closing arguments, and be able to go decide this case. One of the things I haven't done during this case is tell you a whole lot about myself. There's a reason for that. This case is not about me. It's not about those lawyers over there. It's about the life of Tony Paul that was forever changed on the night of this accident because of the decisions of Priscilla White. And that's what this case is about. There's a couple of things that this case is not about, all right? There's no claim that MARTA was negligent in any way. MARTA is here because it's the employer of Tony Paul. So if you don't like MARTA and you don't like what MARTA did, it doesn't matter. If you love MARTA and you love how MARTA trains its drivers, it doesn't matter. What you are looking at is, what did Priscilla White do to cause this accident? And what, if anything, did Tony Paul do to cause? That's the key word here, cause. They put up 10 things, right? And looking at those 10 things, whether he did them or didn't do them, is not the question. The question is did that cause the accident? Or, I would submit to you, the cause of this accident were the bad decisions of Priscilla White. As I was getting ready for this case, one of the things I did was I talked to a mentor of mine who's tried dozens of pedestrian cases. And I was talking to him, I was like, how do you relate this to a jury? And he's a lot braver than I am, and he said, Jimmy, there's only 2 questions that a jury really needs to consider in a pedestrian case. There's only really 2 questions, it's simple. Number 1, was she in the crosswalk? The answer to that question is no. Number 2 was Mr. Polk driving on the sidewalk? And he wasn't. Because that's where people are supposed to be. When they're provided, pedestrians are supposed to be on the sidewalk and in crosswalks. A bus is supposed to be in the road.
Well, I guess you're meant to.
And when you apply the law, that's the benefit about closing arguments. The judge is going to give you an entire packet of law. He's going to read it to you. One of the most painful parts of any case for Judge McAfee and for you is he has to sit here and read about 30 pages, 35 pages of law to you. The benefit is he's going to send it back with you. So you'll have it back there to be able to read. The law is important because the judge gives you the law and you're required to follow the law that he gives you. If you don't like it, I'm sorry. You have to follow the law that the judge gives you. Now, you get to decide how the facts apply to the law, how the evidence applies to the law, but you have to follow the law. And so that's what I want to do is connect the dots for you about why this is a simple case that when you look at the law, the plaintiffs cannot recover under the law that's going to be given to you. And there's two important concepts I want to go over with you about Miss Priscilla White's behavior on that night. Number one is care for own safety. Every person has a duty to use ordinary care for his or her own safety. If you should determine from the evidence that Priscilla White failed to use ordinary care, and this failure was the sole proximate cause of Priscilla White's injuries, then the plaintiff could not recover from the defendants. Here's one that's even more important for this situation. Assumption of risk. When a person knowingly and voluntarily takes a risk of physical injury. What was the knowing and voluntarily taking a risk of physical injury? It's a pedestrian who has a safe place to be on the sidewalk, who doesn't look to the left and see a big MARTA bus, who doesn't look to the right and see a line of cars, and then who walks out into traffic staring forward. That is knowingly and voluntarily taking a risk of physical injury. Here's the next part. The danger of which is so obvious that the act of taking such risk in and of itself amounts to the failure to exercise ordinary care for one's own safety. And here's the kicker of how it ends this case and you find for the defendants. That person, Priscilla White, Calvin White, cannot hold another liable for injuries proximately caused by such action, even though those injuries may be in part attributable to the negligence of the other person. None of those 10 things matter. You know why? She chose to assume the risk of walking out into the middle of that street under those conditions. That was her voluntary choice. You've heard from the experts. You've heard from the witnesses. She had all the time in the world. There was no reason for her to attempt to cross the road there. She assumed the risk of injury when she did. She chose where, when, and how to cross the street. Here's the big thing. The court's already determined that she's negligent. This will be word for word in one of the charges that you get. It tells you the statute that she violated, tells you what the statute requires, and then it says, the court has determined that Priscilla White was negligent per se for violating this statute, for attempting to cross the road where she did. This doesn't even go to the when and how she did it. Just the very fact she chose to do it, the court has ordered that she is negligent. You must accept the court's declaration as conclusive evidence and regard as proof that Priscilla White was negligent per se. They just had the audacity to tell you that was 5%, maybe 10%. That's insulting, quite frankly. That a pedestrian, it's insulting that a pedestrian who can wait. First of all, walk 500 feet. Push a button, wait at the crosswalk, walk across. Safe, not a problem. Hey, maybe I'm going the other way. There's nothing open. It's 9:30 at night. There's nothing open on the other side of the road. She doesn't need to get across the road right there. Where's she going? We don't know. 500 feet, walk safely across the crosswalk. 900 feet, safely across the crosswalk. Instead, what does she do? What does she do? What is her choice? Because that's what it's about. It's about choices. Now, I told you, it doesn't mean she's a bad person. It means she made bad choices. We don't know Priscilla White. Her family doesn't know Priscilla White. We don't know why she made the choice she did. But she made bad choices. And you talk about do your job. Ladies and gentlemen, as a jury, do your job. Follow the law. Look at what Priscilla White did. And they keep talking about primary cause is Tony Polk. Primary cause is Tony Polk? Are you kidding me? Tony Polk didn't put her in the street. Tony Polk feels guilty as hell because he couldn't save her. He couldn't be Superman. This has been agonizing and painful for him. Because he couldn't be Superman. He wanted to be Superman. He wanted to be able to save her. He couldn't. But you can't hold him responsible for that. Who was the primary cause? Who made these choices? Let's look at the universal rules of pedestrian safety. Look both ways before crossing the street. Everybody agrees. Pedestrian, you have to look both ways before you cross the street. She look both ways as she walk out there. The second part. Hey, we know from jury selection, everybody crosses mid-block sometimes. You know what every juror, that all 40 that we talked to said? You're going to decide to cross mid-block. You better look both ways and continue to look to make sure you can make it across, because another universal rule of pedestrian safety. When you're crossing outside a crosswalk, you have to make sure you can get all the way across without a car getting to you. That's your job as a pedestrian. So who wasn't doing their job? Who wasn't doing their job? Priscilla White. Jeff Walsh agreed. They talked about, they didn't hire an accident reconstruction expert. Their experts were some of my best witnesses. Their experts were some of my best witnesses. Jeff Walsh stood up here and told you Priscilla White violated those two universal rules of pedestrian safety. She made a poor decision in attempting to cross the road at a time and place she did. The accident was put into motion by the decision that Priscilla White made to violate these universal rules of pedestrian safety. And the outcome of the situation was not favorable to her based on the decision she made at the time. That she made at the time. That was their accident reconstruction expert. And I know Jeff. I've known Jeff for a long time. He does a good job. But in this case, you'll remember, he's a police officer. He was handcuffed. He was handcuffed because the plaintiff's lawyer said, don't do a full investigation, do a limited. Do a limited one because we don't really want you to come in here and talk to this jury about what Miss Priscilla White did wrong. We only want you to talk about what you see that Mr. Polk could have done to save her. Talk about do your job. So back to assumption of the risk. You get back there and you decide, did she knowingly voluntarily take a risk of physical injury? Walking out into the road with cars coming, knowingly and voluntarily taking a risk of physical injury. The danger of which is so obvious that it amounts to the failure to exercise ordinary care for one's own safety. That's all here. And once that's determined, they can't hold another person liable for their decisions. They can't, because she assumed the risk of injury. She assumed the risk that Mr. Paul wouldn't be able to save her. And here's the thing is, if it wasn't Mr. Paul that was going to hit her, it was the car behind Mr. Paul. If it wasn't the car behind Mr. Paul, it was the cars coming the other direction. You watch the video, ask yourself, when you're back in that room, ask yourself and ask each other, did you see any car react to her? They brought in these experts to tell you, oh, it's so light out there, it's so easy to see. Why is nobody coming the other way saying, oh my God, there's a pedestrian? Right? Pedestrian was that far. You can look at the video, you'll have it back there with you. This white was that far from a car coming the other direction. And that car drove right by her without doing anything. Because she couldn't be seen. She couldn't be seen. Do your job. All the plaintiff's experts messed up the basic facts of the case. And there's a reason they did that, and there's a reason they tried to do that. Because if she's wearing all dark clothing, the times don't work for him. When Ryder would punch in the keys to the IDRR program, if he doesn't select lighter, if he selects darker, the numbers don't work for him anymore. So he had to say, well, because if you shine a flashlight on a black pair of jeans, you see light. Well, she must have been wearing light colored pants. No. You have the medical examiner's report. You have the video. You can see. She's wearing a pair of black denim jeans. She was wearing a navy shirt. And unfortunately, there she is right there in all dark clothing. They mess up the basic, most simplest facts. So why? Because they don't want her behavior to be the proximate cause of the accident. So you're taught with, in these cases, we talk about elements. Duty is, what does the law require? The next one is, did you breach that duty? And then we have proximate cause. And proximate cause means that cause which in a natural and continuous sequence produces an event, and without which cause such events would not have occurred. That's Priscilla White's behavior. That cause, her choosing to cross the street in a natural continuous sequence. The situation was continuing. The whole time. She put it in motion. And it produces the event. Without her choosing to walk out into the middle of the street with traffic coming in both directions, in all dark clothes, this accident never happens. So that's another way. You're going to get a jury verdict form. You're going to get a jury verdict form, and sorry, I don't have this blown up to put up there, but I don't want to stop my PowerPoint. You'll get this form from the court. The very first question is, as to the negligence of as to the allegations of negligence against the defendants, we the jury find in favor of the plaintiff, or we the jury find in favor of the defense. Based upon what I've already shown you, assumption of the risk, causation, you would check this box. We the jury find in favor of the defendants. Flip over to the back page, date it, sign it, and we go home. Based on what I've already told you. Now let's talk about Mr. Paul. So the result of Ms. White's choices, and here's the key part of it, place Mr. Paul in an emergency situation with passengers on his bus. And here's the reason why that emergency situation is important. The next thing I'm going to go over with you is the law. Okay? That when you're in an emergency situation, You don't have to act with the same degree of care if you have time to sit back and think about it. He didn't have time. Their best case scenario from Jeff Walsh was 4 seconds. 4 seconds. There's a clock on the back wall. Turn and look how short of a period of time 4 seconds is. That's it. That's 4 seconds. 4 seconds to perceive, react, and have time to do something with a pedestrian wearing all dark clothing in a dark place and glare in your eyes. If it wasn't Mr. Paul, it's going to be the car behind him. It's going to be the next car over because of the decisions of Priscilla White. So what is sudden emergency? This is what I was just talking to you about. This is the law that applies to Mr. Paul. One who is confronted with a sudden emergency that was not created by his own fault. Priscilla White walking in the road wasn't created by Mr. Paul's own fault. And is without sufficient time to determine accurately and with certainty the best thing to be done. 4 seconds. Is that enough time to determine with accuracy and certain the best thing to be done? Is not held to the same accuracy of judgment as would be required of that person if they had more time for deliberation. The requirement is that the person act with ordinary care under all the particular facts and circumstances surrounding the situation. That's what Mr. Paul did. It's exactly what he did. He did the best he could under the situation with 4 seconds. That's their number. I don't think he had 4 seconds. That's their number. I want to talk to you a minute about themes. Lawyers go to these classes and they say jurors are not very smart. And so you come up with a theme to try. You're smart. You're intelligent people with common sense. Apply it. You don't need a theme, but let's think about do your job. Do your job. Did plaintiff's counsel really allow their experts to do their job? Or do they put handcuffs on them and tell them to do half a job? Everyone said, Paul Kafetz, did you do a visibility study? Did you look at what the pedestrian could see? No, I was not asked to do that. Could you have done it if you were asked? I could have. Jeff Walsh, I did a limited reconstruction. A limited reconstruction. Why did you do that? That's what I was asked to do. I was asked to focus on the bus and the performance of the driver. Kevin Ryder, human factors, went out to the scene. You're out of the scene. Did you look at this from the pedestrian's point of view? So you could come in and tell this jury how far down the road the pedestrian could see. Nope. I didn't have enough information. Didn't have enough information? I don't mean to be condescending about this, but this isn't Star Trek. Scotty didn't beam Priscilla White down to the middle of that road. She got there with her own choices. And as a human factors, as a scientist, they can't come in here and tell you that. Half a job. Half a job. Here's the interesting thing too. In opening statements, Mr. Williams got up as he had to because of the court's order and said,
Whoa. The approach.
Yeah. During the trial of the case, was there any responsibility taken by the plaintiff? Any? Or they try to put it all? Ask yourself that. Expert witnesses. Here's the thing about you as jurors. You get to decide what you consider and what you don't. You don't like what somebody said, you don't believe them, disregard it. You get to determine who to believe and who not to believe. You get to determine what happened and what didn't happen. You don't have to listen to anybody but your own sound judgment. And to each other. You have to talk and discuss it with each other. That's for y'all to decide. Paul Kafetz was one of the best witnesses for us. They made a big deal and opening about they don't have a video guy and a glare guy. You know why they didn't have a video guy and a glare guy? Because I knew when Mr. Kafetz got up on the stand, he was going to be my witness. He had done, hey, look how good my camera is, and it approximates what the eye shows. And it's calibrated to show the view from the bus driver. He told you that they told you throughout the case, glare would never obscure an entire lane. That's just not how glare works. It would never happen. But then Mr. Kafetz got up here, again, one of my best witnesses, and told you, you could rely on the video to truly and accurately depict what a driver would have seen. And then we went through these images. And he decided that a 3-lane highway with 2 shoulder lanes in the middle and a concrete wall was what the situation on Cleveland Avenue, a 2-lane road, was like. And then remember when we went through it with him. If we're going to put Mr. Polk on this road, we have 6 to 8 feet there, concrete wall, and 6 to 8 feet on the other side before we get to that car. If you're going to put Mr. Polk here, you put him on this brick wall. You put him on that concrete wall. And then he told us that entire shoulder lane where Mr. Polk would have been is obscured. Glare would have never obscured an entire lane until the evidence shows that it did. And the evidence shows that it did. And the evidence shows that it did. And this, ladies and gentlemen, if you put Mr. Polk over here where he is, and you put Miss Priscilla White in that roadway where she was, look at it. Because of the glare, he couldn't see her. He couldn't see her. And that's from their own expert. Remember, I asked him, if we put Priscilla White in here with where the bus is, would he have been able to see her? No, she would have been obscured by glare. Everyone agrees that Mr. Polk had to deal with glare caused by the oncoming headlights. Let's look at glare and what you do with that. Mr. Polk told you he had strategies. And he had strategies he was using. When faced with glare, his strategy was look to the fog line. They brought in Lou Grill. Grill was another great witness for us. Perfect. What strategy do you use when you deal with glare? Looking to the right, towards the right line of the road, is a strategy for drivers experiencing glare. With Mr. Polk, they unfairly cherry-picked things out of the CDL manual. We're going to get to the CDL manual in a minute. Well, they skipped right over glare. Skipped right over it. They didn't even tell you about it. We had to tell you about it. Because when you're faced with glare, as everyone agrees Mr. Polk was, what do? You don't look at the forward roadway. You look to the right and maintain your lane by keeping on that line. That's what you do. That's what Mr. Polk did. This was one of the greatest moments in the trial. Hey, if you can play that video. This is Mr. Kafetz's video, and he just let it play. I'm just going to let it play. You see the glare. Now, I talked to you about, at the beginning of the case, about pre-alerting. When you saw that video for the first time, you weren't pre-alerted. You weren't preconditioned about what was gonna happen. Okay? How many people missed the first time it played, there was a car in the middle of the road? Now, there's no glare here. There's no glare that affects that. But when this video was playing, without preconditioning, without being told what was gonna happen, think to yourself, remember back to that moment. Because now you've seen it twice. You've seen it 3 times. You missed that car? Now, understand, this was a recreation of an accident that he had done where a bus hit an overturned car because he couldn't see it. Okay? Here, they know it's there, so they go around it. But think about the first time you saw that video. When did you see that car? You're driving on the highway. You're driving the speed limit. You're driving below the speed limit. Did you see it in time to be able to avoid an accident? Because that's what Mr. Polk experienced on the night of this accident. That is what he experienced on the night of this accident. When you aren't preconditioned, you're not pre-alerted, you don't have hindsight bias, you don't Monday morning quarterback it. That's the experience Mr. Polk had. 4 seconds. Their number, 4 seconds. And here's we can't really seem to get a number. The reason for that simple is because there's not one. There's not a number. Okay? In openings, the plaintiffs told you, available to be seen at 3.5 seconds. Well, that's easy. 3.5 seconds, apply perception reaction time. Apply that Mr. Polk actually saw her half a second beforehand. Apply the glare. He doesn't see her, can't avoid the accident. Paul Kafitz told you it's actually shorter. He's only visible for 2.5 to 3 seconds. Again, apply the factors, not visible. Walsh, so that's the number they're using now. 200 feet, about 4 seconds. But here's the thing, he admits in the picture of where that is, and you'll have that exhibit 51. You'll know the exact moment he says that occurred. She's not there because of the glare. We can't see her. And then we get the outlier. Mr. Ryder, who was asked to do half a job, comes in and tells you 4.9 seconds. 4.9 seconds. Talk about all these experts and all the money that they paid them. These guys are all within a range. Where's he coming from? Compare it to Dr. Krause. He only relies upon scientific studies. Okay? How is science conducted? How do you conduct science? You have controls in place. So you only have one variable that you're testing for. Okay, you test for that variable because that gives you reliable data as opposed to guesswork. And he tells you an assessment of how far away Miss White could be seen in the onboard bus video or on site fails to address what a typical driver in Mr. Polk's position would see when the driver does not expect the pedestrian to be present in the active roadway. What Mr. Polk did lines up perfectly with the scientific studies of how you would predict the drivers would respond in that situation. Let's get to the ever-changing perception reaction times. Lou Grill, 1.5 to 2.5, but it could be longer if unexpected because expectations affect process and performance. Well, that doesn't help them, so we got to get shorter. All right, Jeff Walsh. Well, I'm going to go 1.5 to 2, and I'm going to go 2 because there may have been glare. Ladies and gentlemen, 1.5 to 2.5 is on the lower end of perception reaction time without glare. If you add glare, all these numbers get longer. But Jeff Walsh was honest and said, all right, if I'm being honest about it, I've used 1.5 to 2.5. Kevin Ryder, again, the outlier. 1.4 to 1.8. He says it could have even been shorter. But then we had his reports from other cases. And he had to admit, well, yeah, when it helps my client, I use 1.5 or 1.5 to 2.5. But he couldn't do it here because it didn't help his client. It didn't help who was paying him. Well, let's look at the CDL manual, right? You heard a huge presentation about how important the CDL manual was. What does it say? Put out by the state. Mr. Grill told you it's actually a national manual. All the states use it. What do they tell drivers about perception reaction time? Well, they break it up into two different ones. Perception. 1 3/4, 1.75. To get the reaction to, you add another 0.75 to 1 second. CDL manual gives you 2.5 to 2.75. Did the plaintiffs bring that out to you during their case? So human factors testing. This is what I told you you're going to hear. When you have a pedestrian who's wearing all dark clothing at night, like Priscilla White was, 60% of drivers don't see them. So of the 40%, the average distance is 60 feet away. That Mr. Paul did better than that. He perceived her further than 60 feet away because he was taking action a half a second before. When you add glare, only 5% of drivers see the pedestrian. And I'll tell you, ladies and gentlemen, in opening, I messed this up. I pulled the wrong number. I had a 5.6 there, so I was off 5.6. It's actually lower than what I told you to open. But I wanted to be honest with you about that. Mr. Paul was not the cause of this accident. He sees Priscilla White and takes action to her to avoid her 0.55 seconds before impact. Based on the scientific studies, when you add glare to it, that places him in the top of 5% of drivers. That's the science. So the question you're going to have to ask yourself, you're going to have to ask each other is, do you believe science? Let's talk about the CD. Well, before we do that, again, I want to refocus. I'm talking about Mr. Paul and explaining this to you so that if somebody asks a question back there in the jury room, you have the tools to explain and discuss it. I think the case ends with what we've already gone over. These choices that Priscilla White made. Okay? I think the case ends before you ever get to these other factors because she assumed the risk of injury. Let's talk about some things. The CDL manual has been talked about. This is the rule book. You have to follow everything in here. You have to know, memorize everything in here. And it's over a 100-page document. But then Mr. Grill told us honestly what a CDL manual is. And we know that. The sole purpose of the CDL manual is to pass the driving test to get a license. You have to read the manual because that's what you're going to be tested on when you go get your license. It doesn't set the standard for commercial drivers. The laws of Georgia do that. The laws of Georgia apply equally to everybody out there on the roadway. And that's the duty to be reasonable. That's what it is. That's what our duty is as people, as commercial drivers, as regular drivers, as motorcyclists, as pedestrians, as anyone. Be reasonable. Take reasonable action. But here's how you know. Is something a requirement that you have to do? Or is it to provide you with strategies? I want you to think about. Have you ever gotten a traffic citation for violating a driver's manual? I've never seen it. That an officer can write you a ticket because, hey, the manual says you got to keep both hands on the wheel. You only have one hand on the wheel. Here's your citation for failure to follow the driver's manual. Never seen it. You know why? Because that's not the standard of care. It's tools in a toolbox. It's tools in a toolbox. That's what the CDL manual is. I'm not gonna take the time to go over these with you one by one, but you'll remember the testimony, ask it of every one of their experts. Is a person only focused on the forward road? No. There's all kind of tasks that take your perception or take your attention away from the forward road that are a normal part of driving. That's life. That's what every driver does. That's what every reasonable person does. There is nobody that is just focused on the road ahead. You have to check your mirrors. Bus driver, you got to check your passengers. You got to check your gauges, make sure you're not speeding. Everybody has responsibilities. And all experts agree on that. He said, all these are acceptable disturbances, what Grill said. Ryder said, yeah, I agree with that. It sounds like you're reading out of one of my papers. Because I was reading right out of one of his papers, so he couldn't wiggle out of agreeing with me. Unexpected events. All the experts agree. When a driver encounters unexpected hazards, perception reaction components of detection, identification, and responses may be delayed. The driver's ability to respond to a roadway hazard is also reduced. Because you develop expectations. Where do you expect pedestrians to be? Crosswalks and bus stops. You would never expect a person to be standing in the middle of the road with traffic coming in both directions. That's just not an expected event. So we have the human factors testing. And remember the scientific data. It's scientific. This is what Dr. Krause went through with you. All dark clothing down here. Very, very hard to see. About 59 feet or 1 second away. This is they actually focusing on the eyes. So when does perception reaction time start? 59 feet away. 59 feet away. What do the stats come out to? Only 40% of drivers see. Only 40% of drivers see when there's no glare. That means 60% don't. And when they do see, they start responding 18 feet away. Mr. Polk did better than that. He responded further than 18 feet away. Half a second at 33 miles an hour. You were told it's about 50 feet. He responding 25 feet away. The average driver at 18 feet. All right, now science. We've determined one variable. So now let's add another element to it. What happens? We had glare. That number drops to 5%. 5% of drivers recognize a pedestrian in all dark clothing with glare. Let's talk a little bit more about Mr. Ryder. So remember that report I went through with him. When he was hired by a trucking company to explain the driver rear-ending a car without braking at all and killing 5 people, he says, well, it's okay. Perception reaction time 1.5 to 2.5. You got to add in those glances we were talking about, and the average glance time is 1.25 to 1.5. So if we add the two biggest numbers together, it's okay for a driver to travel 4 seconds before beginning to brake. If we apply what he did in that case, when his client needed him to say it was okay to go 4 seconds, Paul hits Priscilla White under their numbers without taking any action. So you have to ask yourself, is 1.4 to 1.8 reasonable? Is it scientific? Or is it a higher exempt? The other thing is, I'm a big believer if you put your money where your mouth is. He tells you one thing and does another. When he goes out to the scene and he's standing out on that roadway and he told you there's so much light out there, 4 times the amount of light that you need to see a pedestrian. Can he show you a photograph of that? Did he show you a photograph of that there was 4 times the amount from when he was out there? He said there's so much light, you don't even need headlights. But then what did he do? When he went to the scene, he wore a retro-reflective vest because he was not visible to drivers on the roadway. So let's back up Retroreflective vest. That's what happens when you wear a retroreflective vest. You're easy to see. Go back to the scientific numbers. All dark area, retroreflective vest, 200 meters and 225 meters away, you can see them. All right. You've heard a big ordeal about these glasses, okay? And Mr. Paul has told you. I had a restriction on my license. It said to wear glasses. I was not wearing my glasses. Okay? He was asked, does that mean you violated Georgia law? He said, yep. That means I violated Georgia law. But here's the thing, ladies and gentlemen, you get to determine based upon the science of whether he actually did. Because the statute that they're talking about says, no person shall operate a motor vehicle in any manner in violation of the restriction imposed in a restricted license issued to him or her. Provided, however, such person shall not be guilty of such offense if he or she presents the trial court with admissible medical or other evidence sufficient to demonstrate to the satisfaction of the trial court, that's you, that he no longer suffers from the vision condition that resulted in the imposition of the restriction. In other words, that's a little confusing because that's a criminal statute. That's if you got a citation. How does it apply to you? If you determine Mr. Paul presented evidence to you with medical or other evidence sufficient to demonstrate to your satisfaction that his vision requirements met the vision standards for a commercial driver. So let's look at the science. Here's what the legal requirement is. The judge is going to give you the legal requirement so you can look at it. Here's the legal requirement. The law requires the holder of a commercial license to have distant visual acuity of at least 20/40 in each eye without corrective lenses. So what was Mr. Paul's vision without corrective lenses? Dr. Ross, well, the medical record from Belvedere Eye Clinic from 1 month after this accident tells us. And Dr. Ross explained this to you. First off, SC means it's uncorrected. What is his uncorrected vision? OD, right eye, 20/40. OS, left eye, 20/30. Both eyes together, 20/30. Well, Mr. Paul wasn't going down the road like this. He wasn't going down the road like that. He was going down the road with both eyes open. His vision was 20/30. All these numbers equal or exceed the standard. So you get to decide whether he violated that statute or not. But here's the other part about it. It's the causation part. It's the causation part about it. Even if he violated the standard, that's your choice. I'm not going to tell you what to do. That's your choice. Even if he violated the standard, they have to prove that that's what caused the accident. Well, here's the thing. All these scientific studies that we went to are people with 20/20 vision. If people with 20/20 vision aren't seeing the pedestrians, and you say, well, if Mr. Paul had 20/20 vision, it's going to be the same result. It's going to be the same result. It didn't matter. Because at that small of a difference, my eyes are twice that bad. I have contacts that I wear. My eyes are twice that bad. The issue is, and Mr. Paul told you this, Dr. Ross told you this, with that level, 20/20 to 20/30, or 20/20 to 20/40, it's, if I'm all the way back here, and I make out each of those numbers clearly, and I make out the street sign clearly that I'm going to get off on exit 283. But here's the thing, it doesn't keep you from seeing a person. You don't have to recognize who that is. If I'm standing out there on the road, Mr. Paul doesn't have to recognize, hey, that's Jimmy. No, he has to recognize it's a person. And you saw the exhibits in the demonstrative. He said, look at the backboard. Look at the blue pad. Think about a 5'4" object. And he regretted, I mean, he didn't want to call her an object, but we talked about objects and targets because that's what they're called in science. Mr. Polk's vision played no role in this accident because if you go back to the science, rely upon the science, people with 20/20 vision still hit the pedestrian. Still don't see the pedestrian. 5% of drivers will glare with 20/20 vision. So put 20/20 vision on Mr. Polk. Apply the science. 5%. And he did it. He did it. Because his vision didn't play a role. Talk about red herrings. This is the red herring. This is the red herring. Based on the science, the vision doesn't matter. Let's go through their other checklist part of it. 2 hands on the wheel. You remember this part of the trial. Pulled out the CDL manual and said, Mr. Polk, you have to hold the steering wheel firmly with both hands, don't you? Polk said, that's what the manual says. And I made sure we read the rest of it. Why? Why do you need to have 2 hands on the wheel? If you hit a curb or a pothole, the wheel could pull away from your hands unless you have a firm hold. If that's what this case was about, if Mr. Polk hit a pothole and went off the road and hit Miss White on the sidewalk, he's responsible for not having 2 hands on the wheel. It's not what this case is about. It's an illusion. It's to deflect. Actually, let's use a better word. It's glare. It's glare. You're shining a light into your eyes so you can't see the truth. That this doesn't have anything to do with this accident. But when you step away and you step to the side, you can see when the glare is gone, these things don't have anything to do with the cause of this accident. They just simply don't. Scanning, made a huge ordeal about, gotta move your head. Then what did Mr. Grill say? Scan with your eyes. Keep your eyes moving. We had to pull up that MARTA policy. Big picture. Keep your eyes moving. The thing you move is your eyes. If you do what Mr. Polk did and set up your mirror so that you have a complete picture, you take the time to adjust everything correctly, you're moving your eyes. Let's talk about policies and procedures, because policies and procedures are not negligence. Okay? And this is what the judge is going to tell you. This is one of the charges. A defendant's violation of its own established rules, policies, and procedures may be considered as illustrative of negligence, but the violation of such a rule is not negligent in and of itself. That's part 1. Okay? Part 2. What do we want to encourage companies to do? To the extent policies, procedures, or training imposes a standard greater than the standard of care applicable in this case, then the defendants cannot be held liable for violation of any such policies and procedure. As a society, we want companies holding their employees up here. Right? It makes it a safer world. We want people to hold their employees to do the absolute best thing in every situation. But that's not what the standard is. The standard is negligence. The standard is down here. That it's not what a reasonable person would do. You get to decide that. So, what do MARTA's policies and procedures do? They teach you tools, teach you strategies, teach you techniques, so you can exercise good judgment out on the roadway. They're not a set of rules that you have to do this, and then you have to do this, and then you have to do this, because driving's not that way. Driving's a dynamic situation. You have to take different data points, apply those to the strategies that you know, and make decisions with it. It's not robots. I mean, I think about in my own life about training I go through, and computer training in particular. We'll have somebody come in and teach us a new computer program, and they say, you do A, B, C, and D. And I'm like, what? They're trying to teach you how to use the program. But once you learn how to use the program, you find shortcuts. You find ways of doing things that are easier. You find ways of doing things that are better. You don't have to follow it step by step like you were trained because it's dynamic. You're applying the situation to what you see and what you do. And applying those techniques and strategies to a dynamic and changing environment doesn't make you wrong. It doesn't make you negligent. That's what the court's going to tell you. That's not negligent. It can't be evidence of negligence, but it's not negligence in and of itself. So again, back to what caused this accident? What's the reason this accident occurred? It's the decisions of Priscilla White. And so again, back to our jury verdict form. I think based upon the evidence that you've heard, go back there and check, we the jury find for the defendants. You sign it, date it, and we all go home. It's been a long week. I'm not gonna tell you what to do. There's choices on the back. I wanna go through those choices with you. So another choice on the back that I wanna talk to you about first is number 3. Actually, can you pull that up? John, take that down and pull it up. So here's the thing. If you're like, I'm not really sure. I'm kind of confused by what the evidence is. I don't think you will be. I mean, I think the assignment is pretty clear. But if you are, you could say, we're going to weigh it out. We're going to say, how much was Priscilla White negligent? And you have to find that she was negligent because the court's already told you she was. Okay? The only issue is you got to make sure that her negligence was a cause or contributed to her injuries, which I think that's pretty clear that it does. So you can, if you don't want to just check, we find for the defendants, it's okay. You come down here and you make a decision about where to do that. What percent was everybody responsible? Now I tell you, based upon the evidence, if you're bringing Barrett, Tony, Paul, and you're going to do your job, right? Because that's what their closing is going to be. Their final message is going to go back and do your job and award a bunch of money. But if you're doing your job to Tony Paul and about this accident, about the law, you're going to put a 0 there. But again, you have a choice. You can put any number you want there. You can put any number you want there. That's your choice. Use your discretion, use your judgment and decide. Now, if I was a better lawyer, I'd probably sit down and shut up right now. But I'd be committing malpractice to you, or I'd be committing malpractice to my clients if I didn't talk to you about damages, okay? And that's one of the interesting things about this. The way the trial goes is they go, then I go. They go, then I go. Well, this last part's a little bit different. This is the last time I get to talk to you. So they get to go, I get to go, and then they get to go again, okay? And so I got to talk to you about damages and what that's going to look like. So one of the things that you're going to be asked about is pain and suffering. All right. And the evidence on this, I think, is pretty clear, ladies and gentlemen. It comes from their experts. They must prove, in order for you to award any type of pain and suffering, they must prove Priscilla White knew she was about to be hit. Every expert testified she never responded to the bus. Never. You see in the video, she's looking straight ahead. There's been no evidence presented to you, none, that she knew she was about to be hit by the bus. And so, you can't speculate on that. You can't say, well, it's so obvious. She should have known she was about to be hit by a bus. It's their burden. And Mr. Andrews told you, they accept their burden. They have to prove, they have to move across the 50-yard line. They have to tip those scales that she knew. Not that she should have known, not that she might have known, that she knew. And so if you're doing your job, and you're following the law that the judge gave to you, you're going to be required to say, no, you can't recover for that. You can't recover for that pain and suffering. So let's talk about post-accident pain and suffering. Mr. Andrews talked to you, well, the accident happened here. She wasn't pronounced dead up here. That's not what the evidence is. Okay? That's not what the standard is for awarding pain and suffering. What they must prove is that she experienced conscious pain and suffering, that she was conscious and aware and alert and in pain after this accident. Now I'll tell you, the only thing that's been relied upon, they didn't call any witness in here to say, oh yeah, she was conscious, she was, they didn't call any witness in here to say that. The only evidence you're gonna have is the Fulton County Medical Examiner's report. I'll tell you, it says, in fact, she was unresponsive. Okay? It says she was unresponsive. From the moment anybody got there, she was unresponsive. Here's the other thing that, I'm sorry to have to tell you this because it's graphic, okay? It also tells you in that report, on the very last page, that she had brain matter coming from her nose. Okay? And I'm sorry to have to discuss that with you because that's tough. But it also shows she wasn't conscious after she impacted that bus. So again, you have to follow the law that the judge gives you. And you're going to be required by the instructions to enter 0 for pain and suffering there. Funeral and burial expenses. If you decide to award money, that's a legitimate item, you should award that. I don't think you get there. I don't think you decide to award money, but if you do, there's the amount, $3,349.93. If you just recover, you should award that number. No question. So what are the damages instructions going to be to you? When one party is required to pay damages to another, the law seeks to ensure that damages awarded are fair to both parties. Okay? In deciding this matter, you're entitled to consider the evidence pertaining to the person's health, habits, surrounding, and method of living. I told you you weren't going to know anything about Priscilla White. Nobody was going to answer those questions, and they still haven't. Here's what we know about Priscilla White. She had 5 children. She didn't take care of any of them. Calvin White, in his deposition, told you, or I had to ask him and refresh him with his deposition. He hadn't seen his mother since 2014 or 2015. But there were some of those things that changed on the stand, and you'll have to ask yourself, why was the information changing on the stand from what it was given 3 years ago? You have to ask yourself that. The other thing is, again, I told you, I'm big about actions. Okay? And I mean, the issue of what is life work, I mean, that's a philosophical question that goes back to Greek philosophers, and it's a question that as people, it's hard to answer. But I'll tell you, one way to measure what is life is by the relationships and what people show up for you. And during this trial, you've been here 5 days. This entire team of lawyers been here 5 days. Our people have been here 5 days. There's not a single family member, 9 brothers and sisters. There's not a single family member that's shown up for this trial. Other than Calvin White, when he had he's here as a party, and Andre White, when he came to testify. Not a single one of the children showed up. So I ask you, do you see the actions of what you see? Or you believe the stories that somebody told you when they're filing the lawsuit trying to recover? And the question you have to ask yourself is when you consider that evidence. This is tough. I mean, talking about human life. And when you talk about human life is precious. And I don't dispute that a bit. I'm a believer of that. But when you do that, you have to ask yourself, what is fair to Mr. Paul? I don't think you get here. I don't think you award damages in this case. But if you do, what number is fair to Mr. Paul? And I would suggest to you that if you're gonna determine he's responsible for not being able to avoid this in 4 seconds, the number that would be fair to Mr. Paul is $100,000. and being fair to both parties, you're gonna hold him responsible, I would suggest that's the number. Now, they're gonna ask you for a number. And they're probably gonna ask, and lawyers do this in different ways. Some people will give you a time measurement. You determine how long she's gonna live and give her X number of dollars for every second or every minute or every hour or every day. And the whole goal of that is they give you a little number, multiply it times a big number, and get a huge number. They're probably gonna ask you for something that's outlandish, like $1 million. You've heard the evidence in this case. You've heard about the relationships. Is that something that's fair to both parties? Is the number they throw out and the way that they tell you how to come up with these damages, is that something that's fair to both parties? Now, ladies and gentlemen, again, I submit to you, don't get there. When you're filling out that jury verdict form, I don't think you ever get to the point of entering numbers on. Because if you're doing your job and doing what the law requires, is following the instructions from the judge, you don't get to entering numbers on those sections. But it's your choice. That's what the jury system is. That's why we bring people from all across the county to come in here and sit as fair and impartial jurors and you decide these things. And what we ask you to do is to relieve Mr. Falk from that burden and tell him it's not your fault. You're not responsible, and fine for the defense.
Does one of the jury need a break? All right, let's take 5. All right, before we recess, let me put a few housekeeping matters on the record. The juror note I received right after they came out from juror 39 about his potential red eye, I have to renumber as Court's Exhibit 4 and retender, and I've already shown it to both parties. Then marking as Court's 5, the charge. That's what I'm just going to provide to the court reporter as an exhibit. I've got 2 copies in the stack of evidence that will go out. And then the verdict form is labeled Court's Exhibit 6, which would go out to them. Anything else?
Yeah, I did notice a mistake on the verdict form. I do think we have to add a line, burial expenses. We didn't have that on there. You would have to have that on.
And so what would be the title for that? Would that be economic damages or just funeral and
Yep.
burial?
That's what it's limited to.
Agreed.
Anything else? All right, then we'll be in recess. Stay close by. As soon as that light's on, let's keep it going. Got that. Funeral and burial expenses. And I'll relabel. So I'll give this one back to you. And you can have this one because when I'm reading it, this might help you. Just follow along.
I want you to,
You have, where'd you like, I see the, just way at the bottom, I mean, September's bottom.
see it in my bed.
Just brought a picture, that's definitely.
The kind of single part of the true.
So it's always easier to talk the truth.
Well, that's why people are trying to be you.
You know? I want her to be, even though I'm trying to be something. You.
Yeah, fakeness always. Truth, jury. Oh, you're done, relax. So you're done, relax. Burden's off.
No.
Man can only be so much, but
That's what that one girl was like. If I was a better lawyer, I'd sit and shut up. She's like.
When, with all this stuff, and it's been like these scattered. I just wonder if they could have say thank you. Appreciate it.
Oh, no problem. Thank you so much. That'd be wonderful.
Chris, can you talk about assumption of the press form? Yeah. Just this thing on there.
Good morning.
Do you have exhibits in your purpose?
What when you exhibit list. Like YouTube might they give you.
That's what I mean.
Oh, you think it works? You think, yeah.
Yes.
Oh, I think. Video teams.
Yeah.
Okay. These were like good on my side, right?
I got a copy of it last year. With the purge. You guys think it's a great copy. You have to watch this. Half the price of this shit.
Can I have this?
You paid for
it. I've learned that still don't mean I get it.
I've seen that before.
Yeah, Sean.
You know, that's what.
Yeah, just have it at the end. Of the time. Just have it at the end. Okay.
Yeah, it's hard to do that.
No, actually, yeah. Jenny put together plans. So, yeah, we covered me. What they said. Yeah, everything's else being weird. One thing is. Countries on it. Clean it up.
Yes.
You need any to better find yourself. Do a lot of IP cases, we do a lot of connecting drugs, drugs that are streaming. Always little particles that can go through. So, early 2000s.
Come to order. We're still waiting on.
I want to get.
Oh, thank you.
Sean, I need that. I will. Oh. Can you get him? Yeah.
Yes.
Lord. Those.
Okay, well, I don't think I'm gonna have time to get those in. I mean, I've got that document. I can put it up a different way.
Yeah, whatever way it takes to get, I just want those three. So you got that document. Can you get
Yeah.
it that way? Yeah. Thank you. And I'll just call it out when I need it.
All right.
There we go. All right, let's go back on the record. Following up on the verdict form, I have added the funeral and burial expenses, and reprinted a new copy. Numbered this one now as Courts Exhibit 6, and we'll provide that. This is just the verdict form. This goes back to them. Anything else we need to take up before bringing back the jury?
Your Honor, can we get a copy of that one emailed so that Mr. Williams can use it in close of close?
We will do so. Is Mr. Williams hooked up audio visually?
Yes, yes, Your Honor.
All right.
Let me go get my client.
Hey. Literally.
Sorry? Okay. Just hold right there for just a second. All right.
Last for the jury.
Thank you, Deputy Scott. Plaintiff may resume when ready.
Thank you, Your Honor. Good morning. I'm the last one. So I know this is not about me. I never said it was. I just wanted you to know a little bit about me since we. Okay. But I will say this. Last thing you need to know about me is I love quotes. I collect them. I just use them because I think people's thoughts at a moment in time can be appreciated and help you in your moments of time. Before I go there, I want to thank you for your service and your attention for everybody. You guys was listening to Timmy, was listening to Gary. Y'all been so attentive all week, thank you. This is the first person I'm gonna quote is me. That's not doing your job. I know everybody was expecting. When professional bus drivers do not follow their training and safety rules, they die. It's a truth of the matter and the fact in this case that MARTA knew since they've been in operation for 1950. That's why they have these policies and procedures. MARTA says their safety is paramount. They know this truth. Defendant Tony Park, he has over 15 years of experience. He knows it's true. You have a 30,000-pound bus. People die if you don't follow those rules. His wife learned it. You guys have learned it. Another quote I want to do is Benjamin Franklin. A half truth is often a great lie. This week, you've heard a lot of half-truths. We've heard it since the litigation of this case. And then we get here and this litigation with witnesses, lawyers, it's half-truth. Right? Let's talk about some of these half-truths. The videos and photos show what Paul could see. You know why Paul Cafis is here? I'll just tell you. Because throughout this whole case, Marta has tried to tell us that what's on that video, what you saw, with all that flare, not glare, flare, is what was preventing Mr. Polk from seeing Miss White. That's why Mr. Cafis was here. That was the purpose of it. And he showed you the video that Mr. Garbo says was the got you moment. What he was trying to express to you guys is that's what normal drivers see is that type of glare. And Dr. Ryder, who's never talked to Mr. Cafis about this, said headlights are designed that way to go downwards. This whole glare thing. We'll talk about it a little bit more later. But this is just to get you off of what is really going on. Miss White could not be seen on the road until it's too late. That's just not true. And they brought an expert. They didn't do an accident reconstructionist. And I know he thinks that Jeff Walsh helped him out. But Jeff Walsh, a retired police officer, the only police officer who testified here, told you she had time. Now, you know, Mr. Scarborough's a very good lawyer. If he had somebody, an accident reconstruct, don't you think he would have done that and brought it? But he didn't. Because they can't get anybody that's an accident reconstruction to do this, who to reconstruct the accident and tell you that she could not be seen on the road until it was too late. 0.5 seconds. He keeps saying that's all he had time. That was his time he created. It was only 0.5 because his actions. He made it 0.5. We'll talk about that. Paul was scanning on the video. That's what I heard him say. Here, they've been trying to scream this thing. Ladies and gentlemen, I'm not gonna play this video for you. You don't have it back there because we've seen it multiple times. This man is not scanning. He's not, his head is not moving this way one way or the other. It's just not. He admitted to it when I asked him. Andre lied about standing. I know we gotta be zealous for our client. I've been doing this for 26. I have never seen somebody attack somebody who lost their mother, who he claimed didn't have a relationship with, and call him a liar. But he told you, when I was a kid, I went to see her work at the salon. He wasn't saying he knew where she worked at the time of this incident. He made a big deal about it. He said, she never stayed with you. He's like, dude, I was 3. This is what's going on. He didn't come to trial this week or the other people. I'm gonna tell you why. I told him not to, because he was gonna be a witness. That's why he's not here. This is half truths. Miss White was homeless, had no relationships. That's what you was told from jury selection to this thing. And we did not accept responsibility. From the beginning, when we filed this lawsuit on behalf, we said she was in the middle of the road. We've never stopped from that. The reason I had to get all these experts, because they would never take responsibility. Because they wouldn't do what they should have been doing. Guess what, guys? Please don't forget this. Mr. Polk did. I don't know if we was looking at the same trial. This man sat here and told you, I did something wrong. That's what he said. He said, I committed an illegal act in operating my commercial truck in violation of Georgia law. That's what he said. I walked away and said, you did something wrong? He said, yes. I was surprised Then I said, did you do anything else wrong? And we went list by list by list. He gave you 5 things he did wrong. I didn't do that. I'm not making some TV show like Perry Mason. This man did that. And what's so interesting is this. I said this to him openly. I'm not giving you my evidence. Sean Williams' evidence, every witness we put up to support that he was wrong was MARTA's. Think about that. They didn't call a safety manager. Their corporate rep. Mr. Boone, did they bring him up to say what Mr. Park did is reasonable bus drivers? Did they do that? The trainer, Mr. Hamilton, I brought him here for you so that you would know exactly what MARTA said they were supposed to do before we got here. He said all the things he was supposed to do. I didn't bring them up. Lou Grill, commercial truck driver, came and solidified what the CDL manual and what drivers were expected to do. No evidence from nothing over there to say anything this man did was right. Think about that. When you guys are talking and they're going and talking about he did nothing wrong, somebody say, where's the evidence? All these commercial truck drivers, experts, all these bus drivers they got, they didn't call one person to say that man did something right that day. Think about that. He's a good lawyer. He brought you crowds from LA. He didn't find a trucking expert, an accident reconstructionist. Really? I'm gonna quote Mrs. Scarborough. Hindsight bias, Monday morning quarterback. Y'all remember he said that? He said, I'm giving y'all confirmation. And you got your mind right. You know what's so interesting about this hindsight? You don't have to Monday morning quarterback if you get it right on Sunday. And that's all I'm asking them to do. Get it right on Sunday. And they gave us what's supposed to happen on Sunday. Think about this. I'm gonna quote my dad, James Williams. He says, son, always be aware of people moving the goalpost. I want you guys to listen to my dad for that. This is what's been going on. So let me say this. Before I ever met Mr. White, before this tragedy happened to Miss White, before I ever met Mr. Park, MARTA said, not me, these are the things that Mr. Park must do. Policies, training, CDL manual, wear corrective lenses, scan with head and roll, rock and roll, slow down, stop if you can't see, expect pedestrian. But now the defense, good lawyers say she was unexpected. They have whole training policies and videos to expect her. But now, because we're in a lawsuit in front of people to judge their responsibility, now the post has moved. This is Scarborough's PowerPoint he just showed you. Look at all these things. Responsibilities while driving. I didn't say this. He did, right? He just did it. This is what a driver is supposed to do. And you know why that's what you're supposed to do that? Because if you do those things, guess what happens? You see people in the middle of the road. And you then have enough time to recognize, perceive, and react. So this 0.5 that they keep screaming, it was enough time. Here's the reason it wasn't enough time. And he asked you to look at a clock. You don't need to look at a clock. Guess what the clock you should have been looking at? We should be talking about 10 seconds, 15 seconds, 20 seconds. You know why? Because the moment he said he couldn't see, he told you he was supposed to slow down to a condition that he could see. And if he can't, he needs to move over to the road or stop. That's why all this stuff is a red herring. This is their policy. Moving the goalposts again, he came and told you a second ago, oh, I don't even know how you do that. How you scan with your eyes and don't move your head? But guess what? This is what Marta said. To be an effective scanner, you must, among other things, scan at specific time locations. Move your head and eyes during all scans. He tried to say I lied about that. I didn't. Head and eyes, move your body as well as turning your head doing many scans. I didn't say that. Scan your mirrors every 5 to 8 seconds. In other words, active scanning can wake you up from a distracted state. That's what we have here. Been asking this question all for 5 years. Why didn't he see her? Because he was blind driving, y'all. Or sleep. I don't know. But he didn't see her. And there's no reason she shouldn't have seen her. Because guess what? It tells you to watch 12 to 15 seconds. Not my rule, theirs. Now, we're supposed to do our job, right? That's what he said. You got an important job. Everybody has to do their job. You as lawyer, I mean, you as jurors, I heard him. You got to follow what the judge tells you. Now he wants you following rules, right? Miss White has to follow certain rules, right? Mr. Paul, though, oh, you can switch it up. He ain't got to follow the rules when it's time for him to drive. And that's what's going on. Now, the rules don't apply. The ball was going through. Now they changing up the field goal post. Expect pedestrians. So now you know why we're here. Because we said, hey, she's in the middle of the road. She has some responsibility. They say we got none, zero. Yeah, we got all these rules. Yeah, the video shows he didn't follow them. Yeah, but it's not our responsibility. I kind of figured out why we've been missing each other in this case. Mr. Scarborough said this, when I do my computer training, we all try to find shortcuts. You remember you just said that? You can do that with a computer. It's not okay to do shortcuts when you're driving a bus. And that's what was going on here, just shortcuts. And he said about his mentor, he said, was she in the crosswalk? Was Mr. Polk driving on the sidewalk? That's all the 2 questions you guys need to answer. I now understand why we're here. They've been looking at this always to find it out. The interesting, ironic thing about it, they've had an escape plan on this case since the beginning. And they didn't have an escape plan, he admitted, except, oh, I forgot, that fog line. Y'all remember, keep talking about that. Look at the video. He ain't looking at no fog line. He's not. He ain't scanning. But this mentor who probably was a lawyer for MARTA at one point, I don't know who he is, probably defended bus companies. Of course he's gonna say this. He got it wrong, though. He got it wrong. And then I heard she would have been hit from a car behind. That's what I'm talking about, half truths. What car? Showing you guys Defender 6, where it's at the back of the bus. Once again, that's my policy here. That photo is so unclear because that camera is unclear. Now let's talk about why they don't want to take responsibility. The collision and the glare. Let me say this, with the glare, just a few points there, when it comes back up there, y'all talk, I want y'all to think about it. Think about his statement, where he never mentioned glare. Okay, the first opportunity, it's a sworn statement. He didn't mention glare. Also, if the glare is such a problem, why is he not doing any motion or anything to show it's a problem? There's nothing here, there's nothing. Other thing is, the CDL manual does talk about glare. You're supposed to expect, Mr. Paul. You knew it was coming. This is not a surprise, so deal with it. It's the same thing with the lighting. He said he's so familiar with that route that he knew that there were lights out. And yet, he's not looking at the potential risk. Now, let me tell you why all of this really doesn't matter. For this reason. Glare, as Mr. Kafis told you, as Mr. Ryder told you, as Mr. Walsh told you, it wasn't something that prevented him from seeing. He still should have seen it. She ain't seen it. But this is where it gets tricky. This is what you're supposed to expect. There are many accidents at night involving pedestrian, joggers, bicyclists, and animals, right? Then drive slower. See that? Drive slower when lighting is poor, confusing. Drive slowly enough to make sure you can stop within the distance you can see it hit. That's what Mr. Grill told me. That's what MARTA's policies say. And guess who else said it? Mr. Paul. Right here. Tell you why this is not an issue. I asked him, in glare, this is his testimony from here. We went and got it to make sure we wouldn't have no more half-truths. Am I correct? Based on the CDL manual, your training by MARTA, if it is a problem that you can't see, that's their defense. I can't see. Aren't you required as a bus driver to stop that vehicle or pull over or slow down? Yes. Not mine. Burden of proof that Mr. Andrews told you about? That's way more than a field goal post. I got an admission. So glare shouldn't be an issue in this case. Because if you can't use it as an excuse, sir. Is it? Because you're trained, if there's a problem, you stop the vehicle, you slow it down until you can see safely. Isn't that what the rules say? Yes. That right there gets you straight to, we got to figure out who's responsible, who's the most responsible. Because it tells you, glare, he admits it. We shouldn't be talking about glare. We shouldn't be talking about lighting. Everything he was supposed to do, he should have slowed that vehicle down. It's off. Matter of fact, that's the second page of it. Let me go right here. And glare, my base, if there's a problem, you're required to pull it over. So, glare, lighting, not an issue. So what's the third thing, Mr. Coleman? Ms. Pike. Try to pull it. Blame game. It's all Ms. White. You heard him. 100% of this is Ms. White. He said that in front of you after his own defendant that he represents told you that he violated multiple rules, multiple training, and multiple policies. 0 is what he said. So why blame Ms. Walker? You're trying to get a discount. That's what he's trying to do. Or a free pass. But you don't get a discount or a free pass when you kill somebody and your reasonable actions, the law will tell you ordinary care. If you were ordinary care and you did not provide it, and your care or your failure to do that was the cause or primary cause of the incident, you don't get a discount and you don't get a free pass. And Mr. Paul was the primary cause of this. And let's talk about that. We've been thinking about this. The domino effect. That's Miss White. She's in the middle of Cleveland Avenue. She can be seen. But you don't even knock this down until you knock the other dominoes. Undisputed in this case, Mr. Paul took medications that cause blurry vision and difficulty seeing at night. First domino. Second domino, Paul did not wear his corrective lenses. And now, this is like, can you pull up 40-5-30? You have that one? If you don't, I got the jury charge. Here you go. Don't worry about it. He pulled it up. No person shall operate a motor vehicle in any manner in violation of the restrictions imposed in a restricted issue license issued to him or her. Right? Provided, however, at the time of the hearing of such offense, if such person was charged doing and in violation of restriction requiring that he or she wear glasses or contacts, a person shall not be guilty of this offense if he or she presents to the trial with admissible medical or other evidence sufficient to demonstrate their satisfaction at court. This is the escape route they're trying to do to get the discount. First of all, clearly he violated, he admitted it. Number two, he didn't have no hearing. And you know what's so crazy about all of this? He not only didn't have a hearing, when it was time for him to renew, that's why I put the next one in. That's what he still did. Restrictions. So we got restrictions in 20, the time of this incident, after this incident. This not me, this not my evidence. This doesn't apply. He's saying this to you guys to get a discount. When this comes up, say you don't get a discount. He violated and he admitted it. And all this thing about federal law and all this stuff, who's testified to that? That he gets to excuse himself of federal law. That Mr. Scarborough's the only one that said it. He didn't bring a commercial trucking expert to say it. He didn't bring anybody from MARTA to say it. He didn't even ask Mr. Paul to say it, that he had an excuse. So where's this coming from? You can go back. Where corrective, go back to that, yes. Hands, two hands on the wheel, scan with heads and eyes, look 5 seconds away, defensive driving technique, things that he admitted, slow down or stop and pitch until you can see, follow the CDL manual, follow MARTA policies and training. All those things started before he got to the intersection, by the way. Domino, he does his job, he goes, and then he says, I'm wearing glasses at one point. Then I see that there's not no sun, so I'm gonna take them off. Doesn't have a second pair for this transition that he needs. Still know he's required. He's taking medication that blurs his vision, and their own expert said causes him visibility problems to see. And guess who else testified to it? Mr. Polk said, I have problems seeing signs far away. And we go through all of this, you don't do no scanning, you do not check your mirrors, 12 to 15 seconds. And now, after we had a chance to look at the video and come up with our legal defense, now it's 0% fault of Mrs. Her, and we said this, she shouldn't have been in the roadway. In that matter, we take responsibility, but she's not the reason she's dead. She created the hazard, but she did not cause this collision. That's why I said she's not the primary cause. That's why I said it, because the domino effect. One of those dominoes, which this Mr. Paul had every opportunity to stop, he would not have hit the last one. When y'all having discussions on primary, think about that domino effect. Talk to each other about it. Now, by the way, what I'm saying in the domino effect is actually what's in the CDL manual. And I heard this. These are guidelines. Our policies are guidelines. That's that post movement again. Because Hamilton and Boone said you gotta follow the CDL manual. And the crazy thing about it, he's quoting the CDL manual for the general perception reaction time, but everything else he's telling you, don't look at. Don't look at that. Because for that, we want you to use it as a guideline. We'll go back. Your perception of the risk. Let's look at this. When a person knowingly, voluntarily takes a risk of physical injury, the danger which is so obvious, an act of taking such risk. This is the problem. No one walks a mid-crossing voluntarily to take the risk of a bus driver not doing his job, not looking, and just running them over. She did not volunteer for him to be negligent on multiple occasions. She definitely didn't volunteer for him not to have his lenses. Definitely didn't volunteer for him not to scan and do everything a reasonable bus driver does. So this whole thing, this charge is an attempt for them to get a discount. Because they want a free pass for her death. Now, we've been criticizing, I just want to say this, on these experts. So I briefly want to talk about it. I told you about Mr. Cafes. He was brought in to tell you that what you see on that video is not what he saw. And Mr. Polk admitted that. Everybody has actually admitted that in this case. But we keep seeing pictures and videos trying to say that that was glare instead of flow. He criticized, he talks about Walsh, and Walsh was very clear that, yes, Mrs. White made a mid-block crossing and made a bad choice on that. But he was even more clear, that ain't why you kill her. He was clear. And Ryder, this is what Ryder did. They keep saying, we just told these experts to do half the things. We did not. I already knew what Miss White did. Everybody knew it. They didn't know why she did it. They didn't know where she was going. They didn't know the path. So there's nothing to analyze. And why do you need to analyze it? She was in the middle of the road that could be seen. So this whole thing that we were trying to create evidence, that's not true. Not true. And Ross, let me bring you that. Before I get to Ross, Mr. Ryder. Mr. Ryder came in here, explained to you how headlights work, explained all those things he did, and he said to you, what I do is I put in all the categories in a computer and a program that has been accepted and used by human factors experts all across the nation. And most of them do use it. Now, who doesn't? Mr. Krause. You know why he doesn't use it? Because Mr. Krause works for 85% of defense firms. And see, when you put something in that computer, you can't fix it no more, right? Because once you put the data in, it is unbiased. But let me tell you what Mr. Krause does. I know I've deposed him multiple times saying the same stuff. And he's good at it. I wrote the book, No, you edited the book. And I ain't disrespecting them, but don't tell these people book that's 4 versions and you just cut and paste some stuff. You know who else was in that book? Cephas, the one that he tells you don't listen to. He was in there at some point. He got taken out because of bad blood between people. Just because you're in a book and you say you wrote it, doesn't get you the right to do what he did. So let me tell you what he did. He started at the end and then went backwards. Remember he said it? Chris was asking him questions. So you started at the 0.5 second right before, and then you did, that's his reaction time, and you went backwards, added 1.5, using some studies, and now you got, this was not a board. That's what happened. I'm gonna tell you, and then what does he base it on? Some literature, a couple of pages, papers, that had nothing to do with what happened in this case. And all this science that Mr. Scarborough saying 60% does this, 40% don't see this, 5% only see that. That is some papers that had nothing to do with a bus driver riding down the middle of the street, wearing corrective lenses, doing what he's supposed to do, doing all the responsibility. And that's what happened. I asked Mr. Cross when I said it, these papers got nothing to do with this. He says, well, look, there's not a specific paper, but you can rely on this. And when Chris asked him, he said, aren't these people at the side of the sidewalk? Yeah. This has not, do not be fooled. Please don't. Please don't. And Dr. Ross, he comes here, going to criticize us. Dr. Ross is his doctor. Right? All these doctors you could have picked in America, in Atlanta, he chooses his doctor, gives them a specific, this is what's so great. He criticizes us for telling somebody to do something, which we didn't. And he specifically writes in the email what he wants him to know and provides him exactly what he wants to do. I want you guys to answer this question. Ask this to each other. Where is Mr. Paul's eye doctor? We had to get the records, and we requested all of the records, right? Think about that. He says he gets visits every 2 years. Where's that in the record? Please show me that. Not, his eye doctor didn't come here and tell you he could see. And when we get Jimmy's eye doctor, who's never even treated or seen Mr. Paul to come here, he brings some boards that has nothing to do with Mr. Paul's condition. Darren came up here and showed you this board, we got to combine 3 boards. Listen, everybody has a right to try their case any way they want, but you don't have the right to be critical of us when you're doing the thing that you say we're doing and we're not even doing it. You're the one that's trying to pull the wolves over these people's lives. That's what's going on here. So I got to get an eye doctor. And it doesn't matter because he's already admitted he violated the law. The law. So this is how hypocritical all of this is. We want you to hold Ms. Paul responsible for violating the law and not being in a crosswalk. Right? Hear this out. Just think about this. But us who violate a law for vision that you're required by the CDL, the Georgia law, to use, and our defense is we couldn't see, disregard that. Now that common sense, you don't need an expert for that. That makes no sense that your defense is I couldn't see, but I don't have the glasses, but it's okay. And I heard this. Superman. We asking him to be Superman. Y'all recall that? I don't want him to be Superman. I actually just want him to be Clark Kent. Clark Kent kept his glasses on. Glasses on, he does what he's supposed to do. I don't need Superman. I just need a reasonable bus driver under the same and several circumstances to do the stuff that he's trained to do, that the rules say he's supposed to do, and that the law says he's supposed to do. Don't give me Superman, give me Clark Kent, because I know Clark Kent is gonna do what he's told to do. Get to damages in this case and I'll sit down. We talked about Miss White's pain and suffering. Gary talked about it first. Jimmy talked about it. And said it's zero. But before that, or after that, he brought up funeral about $3,400. Okay, and he said, if you're gonna award damages, give us that. I believe he said that because he knows y'all's gonna should award damages. That's what I believe. But I could be wrong. For $3,400, I'm gonna just tell you, don't waste your time on that. We do not want their charity. This man does not want their charity. We don't. So we don't want the $3,500. He buried his mom, he'll pay for that. Don't even consider it. So look at the pain and suffering. You got pre-impact pain and suffering and post-impact pain and suffering. And they kept showing up videos of lights being on her. Mrs. Scarborough is screaming, hey, she should be able to see this big old bus. She should be able to appreciate this big old bus. And then she's careless. Think about this. So she can appreciate the bus. She's careless for not doing something about that appreciation, but she has no pre-impact pain and suffering. You'll see the jury charge. It talks about pre-impact shock fright. Do you not think, even for a few seconds, that right before this happened, that she like, oh my God? Because we know what Mr. Polk said when he hit her. She had pre-impact pain and suffering. She had that. We are gonna ask you to award something for that. She also had pain and suffering. Gary went through it, of how she presented in the minutes and time that she went from being at the scene and unfortunately being on that ground and getting to the hospital. I want to say this to you. Miss White, like some of us, had some ups and downs, some difficulties in her life. But there was nothing more difficult than the last minutes from the time she went there to the time she was pronounced dead. That's the worst point of her life. And there's pain and suffering that the law says you should give for that once we've met our burden. And we've met our burden. I've never had a case where made a burden so much because we've used every one of their witnesses and documents to prove it. You're gonna have all of that. I'm not gonna go through it. This is their injuries, head and neck. You see all the lacerations, you see the hemorrhaging, the contusions. That is significant. You see that. He also said that she had brain matter coming out of her nose. That note you'll see was when that was noted when she got to the hospital. Okay, so it's our contention she had pain and suffering. You decide. That's her head and neck. Now we go to her torso. Liver, spleen, fractures all throughout her body. And then her extremities. That is significant pain and suffering. And then the last thing is her death. I think she had a chance to make it to her 64th birthday. And this accident was tragic for a number of reasons. And I know Mr. Park has been through it. And I'm sorry he's had to. But Calvin, his family had to deal with emotion, and obviously Ms. White has had to deal with it. But it's tragic for a number of reasons, because it was predictable. All these policies and procedures, the CDL manual tells you that to expect Ms. White. It was predictable. It was preventable if you do all the things you're supposed to do, and we've already outlined those. And it was avoidable by the fact that if you do those things and slow down with those conditions or either pull over, she doesn't die on June 30th, 2018. So, as to the allegations of negligence against defendants, we the jury find in favor of the plaintiff, we the jury find in favor of the defendants. Humbly, meeting our burden, you shouldn't take long, we find in favor of the defendant. The reason you don't have negligence against Ms. White, because it's already been acknowledged and we told you she was negligent. We now need to figure out, I told you from the beginning, what's the first issue? Was his actions reasonable to avoid this collision? And we've proven that because he admitted to 5 things that was wrong, and the video showed the other 5. Now, so you go there. You go to the next one, go to 2 and 3. Now, Mr. Scarborough did something kind of sneaky on him. He went straight to 3. But you're supposed to go to 2 first. If you find in favor of the plaintiff, you're supposed to go and do the damages first. All right? You do the intangible value of life, which is her full life, and then you put in the pain and suffering, the pre-impact pain and suffering, and then the post-impact. Then you have damages. So don't skip to number 3, as Mr. Scarborough has suggested, because you're supposed to go 1, 2, and 3. Okay? Now, once you get your damages, then you come to 3, and that's where you decide on the percentages. That's how it works. Don't go straight to 3. That's not how it works. Now, on number 3, remember, I told you they're trying to get a discount for a free pass. That's why he brought up 0. Because even if you put here that there's damages and you put 0, Calvin gets nothing, his family gets nothing. If you put Priscilla is 50% or more, Calvin gets nothing, his family gets nothing. That will give them the discount or the free pass they're trying to get. That's why he started with 0. He wants to make sure that they get that discount. I would suggest to you, when you look at the evidence and the domino effect, and all the dominoes that had to fall before you get to her, there is no way she is more than 50% responsible. He has to be more than 50% responsible. And the reason is he had the control of the vehicle that hit her. That's just the common sense part. He has control of his glasses. He has control whether he follows the rules. He has control of the 30,000-pound vehicle, and he had every multiple opportunity before you get to Mrs. White's negligence. That's why. That's why Gary told you we believe it's 5%, at most 10%. That's why we did that. We're not trying to pull it. It's just the truth of the matter. There's like multiple violations and wrongs before you even get to Mrs. White's wrong. Go back. Can you go back for me, Chip? Stay on. All right, I want to fill these in. We already told you. You should check and go do number one. Number two, the intangible, the pain and suffering, the pre-impact. We believe, based on their own argument, based on the video, we believe that. Can you write that on this? Okay. For the post impact of all those things I had from the medical examiner reports and all those injuries, we believe that is $2 to $3 million. And enlighten conscience of the jury. You guys decide. The last thing is the intangible value of life. And you'll get a jury chart on that. That says the full value of life is what, and I think Gary showed it to me, is the enlightened conscience of the community, the jury. You guys decide that. Your decision. I definitely know that it's more than $1 million in my view, because every life is worth more than that. I know that was the anchor that Mr. Scarborough gave me. And it seems like he's been to these confirmation bias and Clinton bias shows and conferences to do that type of stuff. It's definitely more than that. But let me tell you what I want y'all to think about. And I said it in the opening part. The value of something is what somebody thinks of it and love enough to pay for it. I learned that in economy. That's why real estate depends on who wants to buy it. That's why a penny could be worth $100 million because someone decided they have that much love.
Your Honor. Be approached.
Good brush.
There's things that people love that they value. Some people value autographs or baseballs or cards, and they spend whatever money it is to get it. The value of someone's life is similar. And Gary hit on it. It's based on love. We exist, and our value system is based on how we feel about others and how others make us feel about us. That's what values are. And the reality of it is she was loved despite she wasn't homeless. She did have a relationship with her family and friends. She was loved and she loved. Calvin and Andre told you that. And this is what I remember. My Sunday school teacher, I didn't go to the same church as Mrs. Scarborough. My Sunday school teacher said, love fails. It never fails. Even when you make mistakes, it got your back. Love never fails. Even when you're not the best mother, your kids still get taken care of. Even when you ain't got a home that you own a mortgage, you still got a place to stay. And Mrs. White has made some mistakes in her life. But love never fails. It never fails. And in this case, the evidence is that she was loved. I told you I wasn't gonna waste a bunch of time and blame everybody. Calvin talked to you. And it was hard for him. And you know why it was hard for Calvin? Because they had an up and down relationship. And he was in pain talking about his mother and the fact that they never got to the place that they were supposed to be. That's why that hurt. Andre talked to you because he's at a different point and his age is different. His relationship with his mother was different. And this whole thing that these men are lying about when they saw people, he took our deposition asking various questions. It ain't their fault he didn't go into the details. I got the date wrong, but 2018 was the Christmas we went. And in the reality of she was loved. We have testimony, she had a boyfriend. He said she had no relationships. There was people at the service. She had value. And I will tell you, she was 63. And she had people living to their mid-80s, high 80s. My grandfather just turned 95. Over the next 20 years, it is our position that the value of her life is somewhere between 12 and 15 million dollars. And we believe under intangible value of life, that's where you should put that money. It's your decision, but that's where we believe the damages should go. And remember that if you put a number for Priscilla's 50% or more, they get that discount. They get that free pass. And I submit to you, they should not get that free pass. I will finish with Henry David Thoreau, famous scholar from Harvard. And he said, it's not what you look at that matters. It's what you see. Yeah. And when you think about this case, that kind of sums it up. This case has always been about vision. Mr. Paul was looking, but he didn't see them. He didn't have his glasses on. He didn't follow his rules. He didn't slow down or stop. It's about what you see. I beg you. What the defense has been trying to get you to do all week is look at something here, but not see what's really going on. And we brought these experts, and we put all this evidence up because we wanted you to see what was going on. Please see what is going on, because justice, we believe, requires a verdict in the favor of the plaintiff in damages, as I told you, and we believe seeing this situation as it is, Marshall Park is the primary cause. This is why at most 10%. Thank you for your time today and this whole week. Thank you.
Members of the jury, it is now my duty to charge you on the law that applies to this case. This process takes about 15 to 20 minutes, and you'll receive a copy of these charges along with the evidence that you're permitted to have with you in the jury room during your deliberations. You have been considering the case of Calvin White and his plaintiff versus Metropolitan Atlanta Rapid Transit Authority and Tony Polk as defendants. Plaintiff White filed this action here in the Superior Court of Fulton County, in which he brings a claim against the defendants for negligence. The plaintiff must prove every essential part of his claims by a preponderance of the evidence. This is sometimes called the burden of proof or the burden of persuasion. A preponderance of the evidence simply means an amount of evidence that is enough to persuade you that the plaintiff's claim is more likely true than not true. If the proof fails to establish any essential part of a claim by a preponderance of the evidence, you must find against the plaintiff. When more than one claim is involved, you should consider each claim separately. In deciding whether any fact has been proved by a preponderance of the evidence, you may consider the testimony of all the witnesses, regardless of who may have called them, and all of the exhibits received in evidence, regardless of who may have produced them. If the proof fails to establish any essential part of the plaintiff's claim by a preponderance of the evidence, you must find for the defendants as to that claim. Evidence is the means by which any fact that is put in question is established or disproved. All right, there's been a request to pause the charge, and so we will do that here. And if the jurors can let me know when they are available to resume the charge.
It's clear.
All right, my intent will be to pick right up where I left off when they're available. Before we would go off the record, anything need to be said or heard on behalf of the plaintiff?
I assume the note, Your Honor, was just, can we take a break or something like that?
We didn't get a note. It was just, I think, passed verbally along to the deputy, or maybe he just noticed a raise of the hand that I missed.
Nothing otherwise.
All right, anything from the defendants?
I just want to make sure that the objection we made during close actually was,
It was not, so I think you need to preserve it.
Sure. So, during the plaintiff's, second part of closing arguments, there was, references to, $100 million painting. And at that time, we approached the bench and renewed our motion in limine on unsubstantiated anchoring that, reference to, items that weren't in evidence, the value of items that weren't in evidence, are not appropriate to put in front of the jury. And so we renewed that motion and the court made it.
All right, anything else you want to add, I guess, on behalf of the plaintiff then?
I mean, the motion in limine was not granted. It was deferred, and obviously, I think that's why Mr. Scarborough objected. We have a number of legal arguments why that particular approach is incorrect as to closing. And Georgia law is amongst the most broad in terms of the breadth of closing argument and advocacy in closing argument. It is not a hermetically sealed concept of evidence and record. Otherwise, he couldn't say I'm Jimmy Scarborough because that would be hearsay. But something along those lines. And also, we never reached any sort of threshold where we were going to be violating any sort of issue with introducing evidence as opposed to simply an allegory or otherwise matters within common knowledge.
All right, yeah, I'll just note for the record, 'cause, since the bench commerce wasn't picked up, that I overruled the objection. I'll just note my characterization of the closing at that point was speaking in broad principles and not placing an item on, say, a specific thing that actually exists, and comparing it to a specific thing that exists, just more principally how things value is placed on things objectively. All right, with that, anything else we need to preserve or put on the record?
Not from us.
All right, it seems like the jury's ready to come back and resume.
If that's okay with, I'm gonna run the record, not to sneak back.
You fine with that? Okay. You sure you don't want to miss this? Okay.
All right, hold on.
We all? Maybe they wanted a break because they thought there were 30 pages.
I'm sorry, I didn't. Oh. Thank you, Deputy Scott. All right, members of the jury, I'll resume the charge where I left off. Evidence includes all of the testimony of the witnesses, as well as the exhibits admitted during the trial. Evidence may be either direct or circumstantial, or both. Direct evidence is evidence that immediately points to the question at issue. Circumstantial evidence is evidence that only tends to establish a fact. It must be such as to reasonably establish that fact rather than anything else. The comparative weight of circumstantial and direct evidence on any given issue is a question of fact for you to decide. Your verdict must be based solely on the evidence presented during the trial. It is improper for you to consider your private knowledge respecting the facts, witnesses, or parties. Deposition testimony is entitled to the same consideration as live testimony, and you must judge it in the same way as if the witness was testifying in court. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The case before you is one in which the plaintiff must prove, by a preponderance of the evidence, that the negligence of the defendant, if any, was a proximate cause of the injuries to Priscilla White. The occurrence of an unfortunate event or injury does not authorize a presumption of negligence. Ordinary negligence means the absence of or the failure to use that degree of care that is used by ordinarily careful persons under the same or similar circumstances. Before the plaintiff can recover damages from defendants in a case such as this, there must be injury to Priscilla White resulting from the defendant's negligence. Every person has a duty to use ordinary care for his or her own safety. If you should determine from the evidence that Priscilla White failed to use ordinary care and that this failure was the sole proximate cause of Priscilla White's injuries, then the plaintiff could not recover from the defendants. When a person knowingly and voluntarily takes a risk of physical injury, the danger of which is so obvious that the act of taking such risk in and of itself amounts to a failure to exercise ordinary care for one's own safety, that person cannot hold another liable for injuries proximately caused by such action, even though the injuries may be in part attributable to the negligence of the other person. One who is confronted by a sudden emergency that was not created by one's own fault and is without sufficient time to determine accurately and with certainty the best thing to be done is not held to the same accuracy of judgment as would be required of that person if he had more time for deliberation. The requirement is that the person act with ordinary care under all particular facts and circumstances surrounding the situation. Proximate cause means that cause which, in a natural and continuous sequence, produces an event, and without which cause such event would not have occurred. In order to be a proximate cause, the act or omission complained of must be such that a person using ordinary care would have foreseen that the event, or some similar event, might reasonably result therefrom. There may be more than one proximate cause of an event, but if an act or omission of any person not a party to the suit was the sole proximate cause of an occurrence, then no act or omission of any party could have been a proximate cause. When I use the expression proximate cause, I mean a cause that, in the natural and ordinary course of events, produced Priscilla White's injury. It need not be the only cause, nor the last or nearest cause. It is sufficient if it combines with another cause resulting in the injury. The plaintiff contends that Tony Polk violated certain laws. OCGA Section 40-5-30C provides that no person shall operate a motor vehicle in any manner in violation of the restrictions imposed in a restricted license issued to him or her, provided, however, that at the time of the hearing on such offense, if such person was charged with driving in violation of a restriction requiring that he or she wear eyeglasses or contact lenses, such person shall not be guilty of such offense if he or she presents the trial court with admissible medical or other evidence sufficient to demonstrate to the satisfaction of the trial court that he or she no longer suffers from the vision condition that resulted in the imposition of such restriction. OCGA Section 40-6-93 provides that every driver of a vehicle shall exercise due care to avoid colliding with any pedestrian upon any roadway and shall give warning by sounding his horn when necessary. OCGA Section 40-6-180 provides that no person shall drive a vehicle at a speed greater than is reasonable and careful under the conditions and having regard for the actual and potential hazards then existing. The defendants contend that Priscilla White violated certain laws. OCGA Section 40-1-152 provides that right-of-way is the right of one vehicle or pedestrian to proceed in a lawful manner in preference to another vehicle or pedestrian approaching under such circumstances of direction, speed, and proximity as to give rise to danger or collision unless one gives way to the other. OCGA Section 40-6-96D provides that except as otherwise provided by law, any pedestrian upon a roadway shall yield the right-of-way to all vehicles upon the roadway. A violation of any of the statutes and provisions that I've just described to you is called negligence per se, which means negligence as a matter of law. It is your duty to decide whether such violation took place or not. The court has determined that Priscilla White was negligent per se for violating OCGA Section 40-6-92C, which prohibits pedestrians from crossing between adjacent intersections where traffic control signals are in operation except in a marked crosswalk. You must accept the court's declaration as conclusive evidence and regard as proved that Priscilla White was negligent per se. Whether any negligence was a proximate cause of the injuries to Priscilla White remains a separate issue for you to decide. For the negligence of one person to be properly placed upon another, the negligent person must be the agent of the person to whom it is attributed. The plaintiff must prove that Tony Pauck was negligent in one or more ways alleged in order to recover. It is not necessary for the plaintiff to prove that Tony Pauck was negligent in every way that the plaintiff claims. If you find no negligence at all on the part of Tony Pauck, then the plaintiff's case ends. People are under an obligation to use ordinary care to avoid injuring others after finding them in a dangerous place, regardless of how they got there, and are liable for the failure to do so. This rule is known as the last clear chance doctrine. The last clear chance doctrine only applies when it is proved by a preponderance of the evidence that Priscilla White placed herself in danger because of her own negligence. Tony Pauck actually knew of Priscilla White's danger, and Tony Pauck had opportunity to take action to avoid the injury to Priscilla White by the use of ordinary care under the conditions and circumstances that existed at that time, but failed to do so. If you find such to be proved, then the failure of Tony Pauck to use ordinary care under such circumstances to avoid the injury to Priscilla White would be considered the proximate cause of Priscilla White's injuries. You may consider privately established rules as illustrative of negligence, but the violation of such a rule is not negligence in and of itself. To the extent policies, procedure, or training impose a standard greater than the standard of care applicable in this case, then the defendants should not be held liable for violation of any such policy or training. The law requires the holder of a commercial driver's license to have 1. Distant visual acuity of at least 20/40 in each eye without corrective lenses, 2. Visual acuity separately corrected to 20/40 or better with corrective lenses, or 3. Distant binocular vision of at least 20/40 in both eyes with or without corrective lenses. Damages are given as pay or compensation for injury done. When one party is required to pay damages to another, the law seeks to ensure that the damages awarded are fair to both parties. If you believe from a preponderance of the evidence that the plaintiff is entitled to recover, you should award to the plaintiff such sums as you believe are reasonable and just in this case. In this case, damages may include an amount equal to the full value of the life of Priscilla White, without deduction for necessary or other personal expenses of the deceased had she lived. In attempting to arrive at this value, you as jurors, in light of your own observation and experience, are authorized to take into consideration the value of intangible, non-economic elements which are not capable of exact proof. It shall be measured by your enlightened conscience as fair and impartial jurors. Damages for the full value of life may include the value to Miss White of being alive and being able to enjoy life and living, relationships with her family which she lost by death, the society, advice, counsel, and companionship with her family and friends. In deciding this matter, you are also entitled to consider the evidence pertaining to the person's age, health, habits, surroundings, and method of living. These damages are measured from the decedent's point of view. There is no recovery for damages, including mental or emotional suffering, experienced by the decedent's survivors as a result of her death. Pain and suffering is a separate legal item of damages for you to consider in this case. The measure is the enlightened conscience of fair and impartial jurors. The question of whether, how much, and how long Miss White suffered is for you to decide. Pain and suffering includes mental suffering, but mental suffering is not a legal item of damage unless there is physical suffering also. In evaluating Ms. White's pain and suffering, you may consider the following factors if proven: shock of impact, actual pain and suffering, and mental anguish. Pain and suffering damages are not recoverable if there was no consciousness of pain or the death was instantaneous. If you believe that the plaintiff sustained damages, you must determine the amount of these damages. Do not make any reduction in the amount of damages because of the negligence, if any, of Priscilla White. You must also decide the percentage of fault, if any, of all parties whose negligence contributed to the alleged injury or damages. For any person or entity you find did not contribute to the alleged injury or damages, enter 0%. The total of the fault assessed must equal 100%. The court will enter a judgment based on your verdict, and if you find that Priscilla White was negligent in any degree, the court will reduce the total amount of damages awarded by the percentage of negligence which you attribute to Priscilla White. If you find that the negligence of Priscilla White is equal to or greater than the negligence of Tony Polk, then the plaintiff is not entitled to recover damages. I want to emphasize that anything the court did or said during the trial of this case was not intended and did not intimate, hint, or suggest to you which of the parties should prevail in this case. Whichever of the parties is entitled to a verdict is a matter entirely for you to determine. And whatever your verdict is, it must be agreed upon by all of you. The court's interest in the matter is that it's fairly presented according to the law, and that you, as honest, conscientious, impartial jurors, consider the case as the court has instructed you and return a verdict that speaks the truth as you find the truth of this case to be. Your verdict should be a true verdict, based upon your opinion of the evidence according to the laws given to you in this charge. You're not to show favor or sympathy to one party or another. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. You must consider this case as a lawsuit between persons of equal worth and equal standing in the community, and between persons holding the same or similar positions in life. All persons stand equal before the law, and all persons are to be dealt with as equals in a court of justice. A governmental entity like MARTA is regarded as a person in this instance. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, such as Facebook, MySpace, LinkedIn, YouTube, or X, formerly known as Twitter, to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Your verdict must be unanimous. One of your first duties in the jury room will be to select one of your number to act as foreperson, who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Jurors should carefully consider all the evidence in the case and deliberate with a view toward reaching a unanimous verdict, consistent with your consciences and oaths as jurors. Avoid premature, fixed opinions. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced it is wrong. However, you should never surrender honest convictions or opinions in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. In just a moment, you may retire to the jury room, but do not begin your deliberations until I send you a copy of the exhibits, of the verdict form and this charge, which I will do so shortly. Then you may begin your deliberations. Beginning with the plaintiff, any objection to the charge is given?
No, Your Honor.
And on behalf of the defendants?
We agree you read the charge properly, Judge, as drafted. We renew our exceptions as stated in the charge conference.
All right, so noted. All right, with that, members of the jury, and with the exception of juror 39, I'll ask you to retire to the jury room. Again, food should be delivered at some point, and you can choose whether you want to break for lunch or work through it. It's entirely up to you from there. Thank you. Deputy Scott, isn't that juror 39?
39, 39. 39.
All right, juror 39, you can have a seat if you'd like. What I needed to share with you is, as you might have guessed, the jury is composed of 12 individuals, and often we will select alternates because you never know what's going to go wrong. And you are all our alternate for this case this week. And so you wouldn't be deliberating with the full jury at this point. However, there's a chance we may still need you. So what I would anticipate is that if we are going to need you, it's because there is no verdict reached today, and perhaps we have at some point if the deliberations continue into next week. And so I guess my first question to you would be, since we have you here, on Monday morning, we didn't ask you about this, but do you think you would have a scheduling conflict for Monday morning? All right. So what I'm going to do is, I think we have your contact information for you, a phone number. We're going to confirm that before you leave. And you're going to remain under the instructions I've given you. You're still considered a juror on this case, meaning you can't communicate with anyone, you can't do any research. And what's going to happen is once we find out if there's been a verdict, then we're going to give you a call, release you from your service, and that'll be it. Do you need a juror excuse of any kind? Okay. All right, so this may be the last time we see you. So if it is, I want to thank you so much for your service and for your patience throughout this, and wish you the best. Take care.
Now, can we approach briefly, please?
I mean, okay, sure.
Or I'd just say here,
Yeah.
I just wanted to preview something, Judge, that may or may not become an issue as the jury reviews exhibits. When we provided this to with a thumb drive for the video, she tested it. We were able to pull up the video on that laptop. It occurred to us as we were standing there, if the jury tries to swap camera angles or whatever and cannot get back to that, they may have some questions about guidance with it. I checked, we don't have like a one-page instruction sheet we can get them. So they may just come back with questions later about how to manipulate it. I guess we could take those up on the fly.
Yeah, and I also didn't instruct him about it. And I don't know, did the plaintiffs get a chance to look at the laptop and the setup and the thumb drive and that sort of thing?
No, sir, but I anticipate.
I mean,
It was the two files from Exhibit 4, the player and the video that's been admitted.
what I would say is, it's here, the thumb drive's in it. Why don't y'all take a look? We'll just go ahead and have it open with a charger. And I'll just tell Deputy Scott to provide it to him. And if something comes up, they can write us a note. So it's just right there. And if there's nothing else, then we'll go off the record. I already asked.
Oh, I'm sorry.
Yeah. So logistically, I'll just say, if y'all we'll send out an email if we get a note or any other kind of announcement from him. If y'all could just stay within 20 minutes, the building, that'd be great. And as I mentioned, at 1 o'clock, we may have a lot of folks streaming in, as we kind of got a catch-all plea and arraignment and final plea calendar. But if we get any kind of note or announcement from the jury, we'll pause that, bring everyone in and handle it. Yeah, I think you're gonna need to clear it off. There's gonna be a lot of attorneys coming in. So plaintiffs, you can probably just keep that space over there, maybe just stack it. But I do think, and I think we're done with the audio visual here at least, right? So we could start kind of breaking down some things. But in terms of republishing exhibits, you could keep your things in the front row. That's fine if you think you need that to republish exhibits. But otherwise, you might want to consolidate. Any other questions or any other issues?
You want cell phone numbers from us at all?
I mean, it's a lot easier for me to just send out a mass email than start calling everybody. And that's what we'll do.
Laptop there, or charger arrangement.
Yeah, we've got a charger. I'll send it back with the charger. But just take a look to make sure that, you can't connect to the internet, no programs, no issues. Yeah, we'd set up another court reporter. And we need to put on the record at some point, I guess, that we put this laptop back without objection. Well. Oh, and you got some.
Okay.
But she likes it. The council's She was selling the area. You want more of those? I promise you, by the way, it's the first time I say. Well, yeah. That's tough.
I didn't work through the.
So you're.
Me too. That's like you do in the league. And if you have anything coming for.
Look, at any point, if you are.
You can work.
Send it to the. That's right. Do what I. It's hard to come by. And, yeah, and so you would, we fast track that one too. Right? Okay, and that could be one that's assigned to a specific courtroom. Not
Yeah.
other. Like going away parties a week.
Oh.
So, if you want us to go on it.
Oh, that.
No, I'm gonna stick around.
Can we build it?
And this is the.
I've done
No,
this
this is
guy.
the. This is the. But I'm saying-
No, I'm going back.
Yes.
So you can hear. You can probably do your song. What soccer you know? Yeah.
Well, I appreciate it. You said that straight.
Before we get numbers.
Thanks for being here. I thought that you were very.
Zero is my favorite number. I like to divide by it when I can. We're probably still.
I'm not going to do one. I'm gonna go.
Sure as
they are.
I don't think so.
Sure. Yeah, that is.
Yeah, it makes sense. That's a good idea. After you said that, maybe kind of sooner.
We got a buck right here. It could be on YouTube too. Are they kind of shutting that down?
I have no idea. I'm checking to see if these mics are.
Ones like that.
It's this one.
Well,
Well, the videos. You have to
Yeah, was it?
Here's a box. Here.
Wow.
Put some stuff. I feel like I waited.
Up in the top bunk. Oh, they got.
They, because they're all pretrial arraignment. I'm not sure whether that'll be. That's the kind of thing that normally screen in the house. It might.
What's that?
I don't know yet. My job was easy. I only wanted one box.
Yeah.
By the time it's over.
Yeah. So we'll be done, you never
We
know.
say-
Yeah.
He was channeling them.
We all excuse me for a moment. I shall return.
I'm standing there. So go home, wait.
So horrible.
Well, I wasn't saying it about. You didn't mean it. It was something that I was used to where you
Probably just-
We're not trying.
Yeah.
Making sure that it's.
Yep, thank you.
Oh, yeah, longer, because it makes me. Slide. So. Oh, man. Gentlemen,
Thank you, Your Honor.
I do have to, since we're off the record, I can share with you after those things. Why this guy's looking at us head about the splitting the direct. They're like, yeah, no. All right, well, I don't know.
But Jim is right.
It's your
It's
discretion.
discretion, and
Yeah.
I've had it done both ways. So
Okay, yeah, you're not, everyone was asking, like, yeah,
It-
like,
it-
never seen it.
And all honesty, it worked out because of the timing. It was just better not.
Yeah, I mean, the argument's always efficiency. You really, because you're the.
And then you might pick up, that's always gonna be a very persuasive argument.
Right,
for
why don't they get the question? And, you know, I mean, then you gotta explain, well, this is part of the plaintiff's case, so they get to call it.
And I wonder what that is, that always just been a matter of custom, there's the origin of where it came from. There's like, no one has a right to be uninterrupted, you know what I mean? In the presentation of evidence. So,
We take people out of order all the time.
Yeah.
First that are flying
so the practice, the feedback that I got, like, oh yeah, overwhelmed is out of you guys. Yeah, absolutely, well,
Big fan of.
Sir? You promised me,
Yeah, so I'm gonna take all of these brown boxes, I'll throw it on this, so they're all, the question is, can I get it all back? And I'm gonna put it in the car. Because whatever happens, I'll do it. Oh, thank you very much, John, I appreciate it. You know, great work.
you got a point of contact.
I just need to make sure I add your number to my phone and put you on speed dial. Very helpful and.
Excellent.
We got some Chick-fil-A.
Consider is.
Yeah.
I'll get stuff back. You guys okay?
I got all, everything by hand.
No, that's not mine. As soon as it was on the court reporters.
Is it?
A phone?
Oh, yeah, that's.
Sorry.
Hey, Chip. I'm gonna put this on your.
Oh, great, thank you.
One back.
Yeah, I think that's Vicky's going.
I think I'll put it in your pocket.
So, oh, we're people outside.
Goes in Andy's box.
That's an important.
Exhibit folders, yeah.
Plus random shit.
Welcome to my world.
I never like this.
Yeah.
All right. Well done.
We need a.
The real thing is gonna get all this other crap in that last box there.
Well, you were retained by the.
Good.
That's your old seat for it. Well, that was come back, this.
I've never seen any judge do that.
Well, I didn't think about it.
I've seen other judges, I mean.
You don't need to ask all your.
This is not standard.
About, but,
It's the judge we were talking about earlier.
Yeah. Well, you gotta get that.
Well, see, that's the thing about trial work, is my watch thinks I did get a workout in.
That's right.
Popping up and down for objections.
No,
Count as
man, my
cardio,
heart
Jamie.
rate of dealing with all this stuff.
All right, guys.
Definitely correct. They put the boards on. Before I lifted it up.
Just a matter of pulling the elements, bring them down.
Yeah, let me move this. If you grab those, boards there, cause I gotta get out of here before I get boards on. Get yourself. Actually, I gotta get outside.
Okay.
Hey, let me go, actually,
Just strap
I'll
them on.
just carry those on and do that out. It's one of y'all's. It's not mine, that's. Oh, wait, hold on. Oops. Perfect. Oh,
No, that's all right.
sorry, my bad.
No, it's okay.
All right, I'm gonna leave my.
I don't think that.
Police orders. These are always 2 man, right?
Sean's or Darren's probably.
Thought he wanted it in the front row.
Do what? All right, yeah, I'm gonna come back after I throw this in the car. And then we'll.
Maybe the Sean's or Darren's. It was right there at the table. I'm gonna put it right here. Is that good? Yes. All right, thank you.
That's like this.
Oh, yes.
Chip, I want to say,
You got it?
catch you later, man.
You got it, John.
Luck in
Good
the
to meet
next
you.
one.
Have a safe drive home. Yeah. Thanks, John. Take care. Chip, nice meeting you. See you. Did, Gary, tell me you're headed back to another MARTA? Yeah.
So, Sheriff, we'll see you later.
Yeah. So.
Yeah.
It was.
It
It wasn't.
This is.
Second collision. The MARTA bus hit.
Somebody else before.
Okay, Andy.
Nice to meet you.
Yeah.
All right.
Say hi to Wayne.
I will. In fact, I'll be talking to him a little bit later.
Okay.
All right, you want a water bottle? I feel pointless. Popped it on my backpack.
Water bottle?
Sure. He said he's coming back and
Who is?
not to let people get his stuff.
Where's his stuff?
I don't know why. Just
Oh.
forgot of that.
Oh, yeah.
I don't,
Cause he's pushing 4 boxes up there. I don't like him. But let me get, is he taking the boxes all the way to his car already? Okay, I'll just wait. I've only got the one on sleep.
are you guys going back to the office? or-
No, way in hell.
Yeah, I mean, I think,
No, I mean, I'll probably find somewhere close to here. Either get that snack bar for a minute, check emails, sure. Have anything like
On the
fire on my
motion
email.
calendar from yesterday.
Well, then if it gets past 3, I'll probably leave.
But one of the favors.
Yeah, let's put that.
My mother-in-law fell Monday night. She's great.
I already have those.
She's stable, she's fine. My wife texted me earlier.
Anything
She's been
else?
Transferred
There's a big.
to a rehab place, which is great.
Deputies went
but-
to.
Round 3 is when I become.
Wilson?
Yeah, so.
Oh, okay, yeah.
will you email me when they email you? So I can watch online or come in?
Yeah, that's no worries. That's
Uh,
assuming I see their email promptly.
Hmm.
Jake, you gonna stick around or you gonna head out? What you wanna do?
I mean, the offices that were 20 minutes away, that's our.
And come in now.
Truth be told, if this jury has a verdict in less than an hour,
I was kind of hoping that we might go to lunch, but just give me that time frame. I mean,
There's a lunch place right around the corner that has like chicken fingers and subs and, I mean,
I know,
it's
you know,
food,
that
it's
American
nothing
Deli
good.
place.
Yeah.
I mean, there's places we could drive to that would still be a trip in 20 minutes.
Let me do this.
out.
What were you planning on doing?
Well, first is I think I am gonna take this out of the car after all. I mean, truth be told, I wasn't gonna go far. I was gonna go to that little grab and go place on the first floor where I got snacks earlier and just get some peanut butter crackers and phone call my wife and then check emails on my iPad. I was telling Stephanie, we haven't heard back by about 3 o'clock. I'm probably gonna have to go for the anyway. I'm not sure, it sounds like it's going back in.
Good job, I'm just saying.
But I'm really gonna stop sending applications. Yeah, they actually, might have to go over. I never met anyone. Right after the.
Yeah, I mean, it's early enough, but I think if it was like 3 o'clock right now, maybe you should talk.
Take the car and I'll be back in a few. But yeah, I'm not.
Yeah, he said he's coming back. Not to let anybody take his stuff.
And the ones at the bottom are.
Do y'all mind
Case
sticking around for
management too.
10, 15 minutes? Okay.
Yeah, they go,
Probably at the point.
they need that.
Where would you,
It was 1 minute up to finish
Yeah.
table.
where would you want to
I just
go
wanna
eat?
make sure we got.
There's a couple places,
Yeah.
there's a pizza place over by the Court of Appeals.
Nah,
There's
I-
a
No, I already know
barbecue
what
place
you're
over there.
saying.
What is that one called?
Another
Das Barbecue.
There's a place, I don't know if that's the
That
one,
one.
but that is a place.
When I was an intern for Judge Schwal here, we went there all the time.
on another calendar?
Yeah, forgetting.
You know which
about
one
it.
are they different?
They're
I'm not.
different. They're like 4 different
Okay,
calendars.
that's fine. I'm not doing it.
You go back there, don't you?
But I know there are places relatively close, I just couldn't.
I hope not, that we did, it came out quick.
You met somebody back there, did you?
No, nobody back there. Who you looking for?
You're.
I ain't saying that.
You come in the hallway area.
Okay, yeah, I'll go in a minute. I'm just gonna try to look up for that. This is,
I want a listing.
this one is,
Okay. Then consider the bill of mandate.
Give us 1 minute.
sure, there's a
Oh, well,
your
give me
pie
10 minutes.
pizza.
Let me get some of that.
Yeah, it's Das Barbecue. 42 Bar and Grill. It's not a make your own, I don't think.
Well, they make it for you, you tell them what you want on it, yeah.
I thought there was one other place right next to there, but.
Yeah.
Attorney Mark.
Hey, what's up, going on there? Yeah. All right. Got a lot of cases today.
Any possible
Yeah, actually, yes. I'll tell you,
calendar?
both calendars.
All of them?
Well, there's only 3 calendars. So the final plea calendar, I anticipate some pleas, and the appealing arraignment, I anticipate some pleas. I'm anticipating 35 pleas this afternoon.
Oh, you going out with the bang? Mr. Mark, you going out with the bang? No, they're just talking. Well, you didn't like it right now.
I'm anticipating pleading out all calendars. I'm gonna stipulate that. Huh? Going where?
I'm used to it. Every few years, they send me some.
Mr. Clark.
He can't leave. I don't know what he just said, but he's not, we're not gonna let
I
him.
know, I don't wanna leave.
We're not gonna let him leave.
Let's stop calling Jim.
Every few years, if they take me and they put me.
Say it.
Nothing about.
If it was my choice, I wouldn't.
Yeah, you probably, y'all probably want to leave.
He got talked to your boss, said, look.
I don't know. Maybe you
I
can hold them
wouldn't
in
wanna leave.
contempt.
After it's done.
Oh,
Yes.
I want to stay when the dog gets low.
Well,
Give me a minute, I'm gonna let everybody,
better for them to say, you don't even put them and say, hey, this is your last day, go put it in the box. That happens in our office. Yeah. Yeah, and every time I move to a different courtroom, usually it's every few years, they never say, are you okay with this? We're thinking about moving it. It's always, well, I just want to let you know.
This is happening.
It's happening.
Get ready.
This is happening.
They were just practicing. Try to make it sound.
might want.
Exactly.
You know, as if this is.
First of all.
Compliment sandwich,
Right.
we know what it
And
is.
then you find out the real reason why you're.
It's some kind of sandwich.
You're also the brush.
Pass one here?
I'll just.
I'm at probation, so I'm getting, no one said.
Okay. Oh, Jerry, they not.
Uh-huh.
I'm sitting with.
Still not money.
Yes, there, this is on
Yeah,
the
yeah.
first row.
You can sit on the first row.
I'll let you in.
Yeah, because the jurors might come out.
I'm gonna stay over there.
I'll be-
You can sit on the first
Hey,
row.
everyone, you have many trouble.
Okay.
Hey, good, how are you, man? Good to see you, good to see you. Maybe I could trick my clients thinking we're having a jury trial, which is for all the judges, look, on trial, here we go, we got 12 people in the box.
Mr. King.
Hello.
Welcome back. Those
Morning. Afternoon, I guess it's afternoon. What's this King? How you doing today? How are you? What's up? What you got to say? Probation came. Oh, okay. Probation officer, when she gets here.
What brings you here?
I'm covering for a major case on final plea. What's on the calendar? I don't know. But
It never really
this, I'll be like, hey, judge. Life or his life.
Right, yeah.
So, speaking of, you have the calendar.
I'm on.
Oh, I do actually, yeah. Which calendar are you into?
I think the final plea one.
I mean, I can't give you my calendar, but you can look at it. Just to see.
Oh, no, he's my investigator. He's like, what?
I was gonna let you have it.
Hey, I was like, he looks like a client.
Probably. I'll have to guess.
You got some money. Everybody got a 20.
Lawyers up there, is that all right?
I'm sorry.
Yep. not-
Lawyers in the box?
Now, Laura's gonna be on the first row. We got a, call going on just in case we don't bring the jurors back off.
Gotcha.
There'll be no time. We just said that. Probation comes in.
Afternoon. How you doing? Are you taking down the Silver Chain case too?
Yeah.
I'm about to say, you've been working hard this week.
Yeah.
That's funny. I'm gonna hit Colonel Edwards. Hey. God just called us.
I haven't seen this calendar. Have you seen this calendar?
Yes. Let me see. What are you on?
Chandler. On the final plea. Or since already been special set.
Attorneys, y'all gonna have to make it fit on that first row. We got a jury back there just in case they gotta come out.
Here's mine, just transported here. I just.
That's real weird.
I'm in.
Oh, no.
He does it all the time. Anytime I bring from the office and come over here, have to start all over. Richard, let me see your final plea column for a second.
Yeah.
About Wednesday.
Thank you, Richard.
I got
Yep, number 2. Number 2.
you. Yeah, I got you.
All right.
Ready for the holidays?
I'm getting ready.
Yeah, good.
Not really, but getting ready.
Yeah. Same here. Yeah. Put the Christmas tree up. Christmas tree position.
So I got, I'm gonna
And then
tell
after
Brian I
I put it
ran
up, I don't like,
into
I
you.
want to take it down.
Nice.
Because I'll commit to anything months in advance.
Yeah.
That's
Who
right.
knows?
So right now you are committed for March and May.
That's good.
I'm gonna be like, Brian, I
Yeah.
ran to God, he verbally told me he is committed to.
Oh, that's
the
great.
chair.
How old's your son? All right, well, yeah, that's more special than your son. Mine's 18. He probably doesn't care about the Christmas tree. He just wants to go out with his friends.
Right.
Generation these days. Kids. They feel like they're entitled to everything.
That's right. That's right. My son's getting there.
You know, it's like, they just, you know, it's a different generation. And I see the younger lawyers, some of them are, seem a little bit like that. Oh, I do that. Well, it's your job. You know?
I'll let you know.
See, this will now come on down, the trust got that fit beside. All right, get up there, everybody.
All right, we've got a couple of calendars for this afternoon. Plea and arraignment, final plea and a revocation calendar. Let me just kick it off at the outset on some reset bond motions. So we got a lot to get through, and I'll also flag we've got a civil jury deliberating. So at any point, if we get a verdict, we're going to have to pause things for a moment. I'll start off with those of you who are here for final plea. You could feel free to announce that you're holding for your announcement. Anything not resolved today, I think we've already noticed for the January trial calendar. We got 2 weeks noticed with a calendar call on the 8th and the first trial week beginning on the 13th. And then those of you who are here for plea and arraignment, what that means is that you have been charged with a criminal offense by the state of Georgia. And we have 2 things we want to achieve today, which is the first one is to see if you're represented, if you've already retained private counsel. And if not, we're going to see if you'd like to fill out some paperwork to see if you qualify for public counsel. And then we want to make sure that you're informed of the charges that have been returned against you by the grand jury. So with that, why don't I just start with final plea since it's a little shorter. And so we kick it off with Mr. Adams and Juan Robinson.
Good afternoon.
Good afternoon, sir. All right. And on the state side,
It's gonna be me, Your Honor.
have you all got an announcement and we want to hold?
We don't need to hold our announcement at this point, and thank you, Ms. Willingham. She shared with me on yesterday a recommendation that I've shared with my client. He has declined that recommendation, and so we'll be going forward to trial. We already have our notice for the 8th, as I understand it, and then the week of the 13th, if I'm correct.
Any discovery issues?
No, I think we've got everything. It's been through a couple different hands, and we've gotten everything.
I didn't see any pending motions, so I think we're good there. You definitely going to be with us in January? Do we know yet?
I don't know, Judge.
Yeah. So it's still just up in the air.
Yes.
All right. Is there any kind of an expiring offer we need to have on the record of any kind?
Yes, Your Honor. The state's offer would be a 10-year probation offer, and that offer would expire today.
All right. And so I think that Mr. Adams, I mean, that's been conveyed to your client. He understands it. And
It has. It's been conveyed. It's a 3-count indictment. We've discussed it, and we are declining We understand that the offer is withdrawn after today. We're declining it. We are ready for trial.
All right, we can make that part of the record as part of my notes when we would begin trial on the case. All right, with that, Mr. Adams, if you don't have any, I think you may have something else, so. But Mr. Robinson, stay in touch with the attorney. We'll see you at the calendar call on January 8th, where we can discuss any logistical issues, figure out what's on the short list. Position 2 was Ryan Chandler with Mr. Steele. I don't know if you, oh, he's on Zoom, okay. There he is. All right. Again, the reunion tour. All right, we had I think the state, we're having a change in lead on this case as well, right?
Correct. It will happen next month, Your Honor. Mr. Brian Watkins will be substituting in as
Okay,
counsel.
and Mr. Chandler, you don't have to stand. You can, I see you here. So Mr. Watkins is taken over, and I think everyone's on notice. We've got it specially set for the 17th to accommodate some scheduling issues. Has a state been able to convey an offer on this case?
An offer was actually conveyed prior to indictment. We gave Mr. Steele an offer. I think it was to reduce
I don't really, I just want to make sure he's
Yeah,
got one. Is that
he
still the
did.
same offer?
I believe that offer has expired. This was a case that was reviewed by the district attorney. Before we went to indictment, we're offering to accuse as all misdemeanors with probations. I believe Mr. Steele turned down that.
Really, the only thing I'm interested in for today is whether, and maybe Mr. Steele can jump in here, if there's something on the table still, and even if there's not, if the defense isn't interested, we can just further notice it from there and then talk through any more logistical things.
I think we could, it would have to the indictment would have to be accused into misdemeanors but the offer could remain open.
Is that, Mr. Steele, something that you're taking up through conversations with the state? Essentially, I mean, basically it's just to ensure there's some communication still ongoing. Anything you want to jump in and add, Mr. Steele?
And good afternoon, Your Honor. Good afternoon, everyone, and happy holidays. Your Honor, the prosecution has been nothing but professional. They have conveyed an order or an offer, rather, to us. And Mr. Chandler, or Officer Chandler, is, I guess, still considering, but he has rejected it, Your Honor. I know there's going to be a new district attorney, so I presume it would be prudent to discuss that with the newest assistant district attorney as well.
All right. The only other note I wanted to convey here is I didn't see any pending motions except for a Daubert motion filed by Mr. Steele. It didn't really identify a specific expert or a particular prong of the Daubert standard I'm supposed to be looking under, so I wouldn't schedule that for a motion until it's particularized. And the other thing I would flag on that is we've got a standing order here that requires both parties, especially in a case like this where we're talking about potential accident reconstructionists and et cetera, that each party has to provide notice to the other side of experts well in advance, along with a meaningful summary of their opinions and conclusions, that sort of thing, kind of consistent with the federal standard. So if that's already been conveyed to you, Mr. Steele, and you want to particularize it, I'll schedule it for a Daubert hearing if I think the motion calls for it. But otherwise, just, I guess, want to tell both parties to be mindful of kind of their expert disclosures on the case.
Yes, we did that. The state does have his expert. We provided that expert report to Mr. Steele in discovery already.
All right. Then if that's it, I think we would just see it a calendar call that may occur in early March, unless there's anything else you can think of, Mr. Steele.
No, Your Honor. I want to thank the court for allowing me to appear in Zoom, and I will talk with Mr. Officer Chandler as well after you let us go.
All right. Take care, Mr. Steele. And Mr. Chandler, you're free to leave. Stay in touch with your attorney.
Thank you, Your Honor.
Thank you, ma'am.
If I may be excused, Judge.
Take care. All right, we're back with Mr. Adams on Mr. Rhodes, positions 3 and 4.
Yes, sir. Normal Road. Mr. Rhodes, are you here? He's not here. I'm going to ask the court not to issue bench warrant though, for this reason, simply because I think the number of notices that were coming in might have been a little bit confusing. When I spoke to Mr. Robinson earlier, he thought he was supposed to be here in January because he'd gotten those notices. So I apologize that Mr. Rhodes is not here. He's been here before. I asked you to not issue a bench warrant. In regard to our announcement, I believe the state is represented by Ms. Alicia Taylor.
I think it was. I think now Ms. Taylor might have been reassigned. No, I'm sorry. Yeah, this should still be her. That's right. Okay.
I received an email from Ms. Taylor, I think 2 days ago, and I
There we go.
responded to the email. I haven't heard back. I don't know what the offer is. We received an offer previously from a from Ms. Willingham when she had it back in February.
Well, she might have had, it might be also a split thing where Willingham has one and Taylor has the other. And that's something I wanted to try and clear up today before we left is if there's an objection to joinder from either party. I mean, I think the court has the power to do it if the case calls for it, but if it's also consented to, I would just note that in an order.
I guess whenever we get someone from the DA's office here to speak on it, I can tell you, I'm probably not gonna have an issue with the joiner because they're related. And my position is gonna be that we're ready for trial anyway.
Yeah.
Unless, well, let me not say that so definitively because there was a probation offer previously, global resolution for both of them. And the email I got recently from Ms. Taylor seemed to suggest something totally different.
Okay. Can we reach out to Ms. Taylor perhaps?
Taylor's in trial, Your Honor.
The
only note she gave me is that discovery's been served, recommendations have been given. She said she had not heard from Mr. Adams.
She's in trial this week, so maybe she missed your email 2 days ago.
Voicemail.
All right. Was Ms. Willingham coming back?
Yeah, she just stepped out to talk. to
Okay.
people.
Why don't we wait for her to come back in? Maybe she can clarify some of this. But if not, we'd see at the calendar call on the 8th, I think, and you can hopefully clear that up. Sure. Sounds good. All right, moving on. We have Hugh Ford with Mr. Marks. I think that would probably also be with Ms. Taylor.
Yes, it is.
Yes, Judge. I'd like to hold for my announcement, communicate an offer to him, but I anticipate he'll reject it and we'll just further notice it to the trial calendar. I think it's already on January's trial calendar.
Understood. Position 6, Lawrence and Melrose.
Same announcement, Your Honor.
7, Samia Daniels with Mr. Lawimba. Is there a Samia Daniels here today? Seeing none.
Page one, Bob, for Your Honor.
All right, we'll reach out to Mr. Lawimba to see if he's heard anything, but assuming good notice, that'll be granted. Position 8 was Keenan Crane with David Heath. Afternoon, sir.
Crane is present, and it's my understanding we're on for final plea. I just need to get with Ms. Russell about an offer.
Yeah, I know we had to reset it because you didn't get one last time, right? Well, now I don't think Ms. Russell's with us any longer, and so we need a replacement for major case, or we have one. There it is.
I don't know who the official ADA is. It's going to be assigned. I'll be here.
Do you think you'll be able to have that conversation, a meaningful conversation with Mr. Heath, or about Mr. Heath?
No, what I would offer in the case, but I can certainly have an attempted meaningful conversation about what a proposed offer could look like.
All right, we'll take it from that. I think he's going to see what he can do, and y'all can talk. I didn't see anything else on this. This is the last position on the final plea, so I'll just hold for y'all to come back, see if you've achieved anything.
Would this be further notice to the January trial?
It will be. It's on the calendar call for the 8th.
Okay.
All right. There we go. Any enlightenment you can give us on roads?
Judge, so as to one of the cases on roads, one was mine, and at the time, ADA Wiggins was still with our office, and her and I both thought that maybe we could do a global probation offer. She never solidified an offer on her case. I was comfortable on mine. But ultimately the case that she had was inherited by ADA Taylor. And since there was no formal offer on that, whatever ADA Taylor has offered on hers would be the leading offer at this point. I mean, mine, I was still fine with a probation offer. I believe that was where ADA Wiggins was leaning, but I'm not gonna overstep Miss Taylor on her case.
Can you remind me but they both had the same lead charge. Is it the same alleged victim?
Yes, to the extent that actually when we concluded the calendar, the last time this case was on, ADA Wiggins also was saying that she was going to take both of them, which would really give them both to Miss Taylor. I did notify Miss Taylor of the same, so she's now aware of that. But again, obviously my offer that was on it would have been honored, but it doesn't change that her offer has some in custody time.
So bottom line, we just need to get Miss Taylor looped in, and it sounds like she's going to be the main point of contact going forward.
Like we'll be talking on the 8th, is what it sounds like to me.
Yeah.
For right now, the announcement's not guilty. There's a time offer on the table. We're not taking that. It's going to be ready for trial unless we, and I'll reach out again.
Yeah.
We'll have something different for you by then.
Sounds good. And issue it, calendar call.
That's fine.
All right. We'll see you in January. Thank you, Mr. Adams. Take care.
Holidays.
All right, moving on to our plain arraignment calendar. We begin with Mr. Napoleon Daniel in custody.
What happened on morning?
Any idea, Mr. Marks, who might take that one?
What position? Oh, this
Number
will be,
No.
I don't know why it's not mine. I can find out though. Napoleon Daniel?
Yeah.
Yeah.
Someone entered a limited appearance and only handled his bond. So I think he's up for grabs for arraignment. So y'all might just want to
I'll take
initially
it,
just
Judge.
check in with him, see where he's at.
Sure.
I also note from kind of studying the file, he's serving he just got back from the feds and they sentenced him, I think, to 10 years. So he's currently under sentence there. All right, so
In custody here today, Judge?
he is.
Okay.
He is. So
You did that? All right. I'll
Had
talk
to
to
run the
him.
card, whatever he got from the feds.
I'll see what I can.
Yeah.
position 2, we had Christian Randall. I believe that's with Mr. Cross.
President Judge,
All right.
Max Ford from Ms. Cross. Mr. Randall is here. We did file a motion to lift the hold on this case, and we'd like to go forward with that.
All right, would the state be ready to be heard on that at some point today?
No, does this case have, I can't remember, he has 3 cases.
He has another one. I think we already arraigned him on. I think we did arraign him on the 3rd one. So he's here for arraignment on the other 2. And yeah, so
I just want to make sure the bond is still good on this case, because he already made bond on this case. And I think at the time that he actually, the hold was put on it, he was actually in custody somewhere else.
right. Right. So while he may be entitled to have the hold lifted for the failure to appear, I think it's worth exploring at that hearing whether he's still entitled to have bond on any of these based on all these charges in these cases.
I'll be ready, Your Honor.
So we can explore all that. I think he's in custody in the back. Have you been able to meet with him?
Yeah, with the
Okay.
deputies helping.
All right. And for his announcement for arraignment, is that anything we need to have on the record? Are you prepared to arraign him on 2 and 3?
We are pleading not guilty and waiving arraignment.
I would just inquire if that
Sorry?
includes number 3.
Oh, you're only on 2.
I'm only on 9909.
Okay, so we still need to get him arraigned on 3.
Okay.
And anyone have any idea whose that would
Going
be?
for me.
Okay.
If you're not hiring. I'll check with them.
We'll figure out where we're going. Okay, position 4, we have Arnold Jackson in custody.
That's mine, Judge. If we could hold out, I'll talk to Mr. Bridges about that.
Is that Ms. Willingham's?
Gonna be me, Judge.
Or Ms. Willingham. Okay.
And let me go back just for a second, just to make sure I got these notes. Number 2 is Mr. Bridges. Number 1 is Mr. Bridges.
Yes, Judge. The first position that's mine is 4.
All right, moving along. Position 5, Anthony Jones. Do we, there's a active failure to appear apparently?
Here.
Oh, there we go. Okay, well, we got something to resolve here.
If Mr. Jones qualifies for our services, then I will represent him.
All right, Mr. Jones, have you secured private counsel for your case? Do you want to see if you qualify for the public counsel? All right, there's some paperwork you got to fill out and then we'll be with you,
I
okay?
believe he already qualified for our services, so I'll speak with him.
Okay, and work through that. Who's got that on the state side?
I do, Your Honor.
I'll talk to him.
Position 6 is Jamal Freeman, I believe, appearing by Zoom and from Department of Corrections. Do we have anyone on Zoom? Yeah. And I'm seeing Mr. Simonov. I'm assuming this is also Mr. Bridges.
Yes, Your Honor.
We'll see if we can get him on Zoom from DOC. Number 7 is the co-defendant to that case, Chanel Lamb. Do we have a Chanel Lamb here today? Another Zoom, okay. And that one, Mr. Dark already filed an entry. We just need a waiver of arraignment, right? Okay, we'll wait and see if Mr. Dark's coming today. Position 8 was Johnny Peebles.
He's in custody, Judge. If we could hold that one. He's also got a probation case that I'll see if we can resolve both at once.
Yeah, I mean, I'll just note on that one, it looks like he pled a month before this case, so we'll see where that takes us.
Right.
All right, position 9 is Philip Williams. Do we have a Philip Williams here today? Good morning, or good afternoon, sir. Have you hired private counsel? Do you want to see if you qualify for the public counsel?
I think I do, I don't think pronounce his name, I'm sorry. Excuse me.
You might have had one earlier, but once you're released on bond, you have to requalify. So there's some paperwork you got to fill out if you still want to go for that, okay? All right, we'll be back with you. Reginald Roberts. Is there a Reginald Roberts here today? Seeing none. Who will have it if he's located?
Me, Your Honor.
Thank you, Mr. Marks. Position 11 is Donnie Holland. All right. Good afternoon, Mr. Holland. Have you secured private counsel? I can't hear you very well.
Picture from my ex-wife.
Yeah. Okay, well, we're going to work through all that. So what I mentioned earlier is the state, through the district attorney's office, has returned an indictment against you, charging you of certain felony offenses. And so what we want to do here today is make sure you know why you're here and what those charges are, and to see if you have secured representation. It also sounds like we need to make sure you got the right address. You need to update your address.
The issue is, at that moment, I gave the appropriate address, but for some reason, certain court documents keep going to my old address, which is the house that I share with my ex-wife, instead of my current address. Some things come to my current address and some things go to the prior address.
Okay, well, let's try this first. Do you want to see if you qualify for public counsel? All right. What we'll ask him to do is tell us your current address. We're going to make sure that matches up with where the notices should be going from here on out. Who has it from the state?
That would be mine, Your Honor.
Got it. Position 12 was Ann Yunha. Yes, that's right.
Be mine, Judge.
Okay. Holden. Who's got it?
Be mine.
DB. Position 13, Jeffrey Hillman in custody.
That's mine.
Got it. And from the state?
I'll have that, Your Honor.
Thank you. 14, Kimsha Redding. Do we have a Kimsha Redding in custody?
That's gonna be mine.
DV. And on the defense side, position 14.
That is conflict, Judge.
Ah,
There's a attorney Pozo that entered.
is that already the conflict attorney of record?
Well, yes, that's the ARPD assigned attorney on the pre-indictment stage, but
Okay, so we need a new conflict attorney.
I'm not sure how they're handling it right now, Judge.
All right, we'll see if we can, maybe Mr. Dark was going to join us today at some point. If not, set it and refer it along. Position 15 is Daryl Smith. Do we have a Daryl Smith here?
Judge, that case was dismissed in June of 2023. And the address information on it may be outdated. He actually can't update his information on closed cases. The clerk won't take change of address forms on closed cases.
Huh.
So I'm not sure that he would have gotten notice of his address changed. It was
Okay.
missed a year and a half ago.
And so what happens if they do try to update their address? Is it just they say kicks it
I
back,
think
or
that there's no, they just tell them that there's no open case to update your address.
that's
on.
interesting. Any input, thoughts from the state?
Your Honor, once it was
Because it's
indicted, he should be able to open case at that point in time.
Yes, but that was a year and a half ago that it got dismissed and it just got indicted.
So basically, I guess the argument is in the last year and a half, if he wanted to update his address, he couldn't have.
People that get their cases dismissed at preliminary hearings don't get notified that they're indicted. Necessarily, so.
All right, I'm going to follow up with the clerk's office, and this is position 15.
And that's just my understanding.
Yeah, I'll try to explore that some. You know, if someone attempts it and then they reject it, do they make a note or something like that? Or is there any kind of paper trail? And we'll look into that.
And I can, for our part, try and contact him with the contact information that we have.
Sure.
If we want to hold on that.
This would be yours
It'd be
if
Mr.
he
Marks.
qualifies? Oh, it'd be Mark's. All right. Okay, we'll come back to that one. Position 16, we had Bilal Muhammad.
That's mine, Judge. He's here.
He's here, okay.
If we could hold on that, I'll make sure that he qualifies and then he and I need to have a conversation.
All right. Just tell him. And Mr. Bridges, is this yours?
Yes, Your Honor.
Okay. Position 17 is Tamir Jones.
Your Honor, Michael Lambros, on behalf of Mr. Jones, who's right next to me, we waive arraignment, enter a plea of not guilty. And I filed an entry of appearance before I got here today with a standard motion. I don't know if I need any more time to file, but.
No, so I'll just tell you where we go from here. If we can get you to sign a copy of the indictment indicating the not guilty plea. And then we're going to enter a scheduling order that's going to have the motions deadline at least a month from here. And we'll follow that up with a case management hearing over Zoom that only the attorneys attend just to make sure you got all your discovery.
So you knew this is the first time I've been before you. Thank you, Ron.
We have a recurring cast of characters here, and you haven't joined our carousel yet. Who's got it from the state?
I do, Your Honor.
Okay. All right, then. We'll see you next time, Mr. Lambros. After you've signed the indictment, free to leave. Take care.
Thank you, Your Honor.
All right. Position 18 is Philip Turman. Do we have a Philip Turman here? Oh, okay. And so, Mr. Turman, do you have an attorney on your case? Do you want to see if you qualify for public counsel? All right, they're going to have some paperwork for you. Who's got it from the state?
I do, Your Honor.
Just following off of that.
Position 19 is Timothy Turner. Ah. Okay. All right, so just want to have someone talk to them soon. We'll do a breakout room whenever someone's got a chance. Would that be, you know, who would have 19?
That'll be me, Judge.
All right, so just whenever you have a moment, we could put you in a breakout room with Mr. Turner. He's joining us by Zoom. Okay. Who from the state has 19?
I do, Your Honor.
Okay. We move on to position 20, which is Leroy Bell in custody.
Will be my case, Judge.
Mr. Bridges, position 21, Arquez Jackson. All right, welcome. And same question, sir. Have you got counsel on this case?
Actually, it'd be Mr. Simonoff.
All right, we'll confirm that that's going to be the case, and we'll get back with you. Mr. Bridges, this is yours, I take it? All right. We have position 22, Robert Ragland in custody. I think Kenneth Mitchell was entered maybe as conflict before, so now we need new conflict. All right. Is this one yours, Mr. Bridges?
Yes, Your Honor.
Okay. We probably just need to notify conflict and reset this for P&A. We'll see if Mr. Dark's going to come today.
Judge, I'm not sure that Mr. Mitchell is on there as conflict. I think
You think it's as private counsel?
I think his entry may have been after he was.
Are you seeing it on there? I don't have it pulled up.
I saw it yesterday, I think, but I'll pull it up and double check, Judge.
Your Honor, as I understood, he went to the solicitor's office in Cobb County.
Never mind.
Oh, that's true. That's right. He's in the solicitor's office. Okay. So he just needs new counsel. So actually, one of y'all need to talk to him, I suppose.
We can qualify him, but he would be going to conflict if Mr. Mitchell was assigned as conflict counsel.
But you're saying maybe he did it as private counsel when he was private?
In 2023.
Because he kind of did both roles.
Oh, I don't know if he was private in 23 or not.
Yeah. He joined us in like late 2023, like really late 2023, like December or something.
That's right, the entry wouldn't really answer that question.
Brandon Wilson was the conflict defender's office representative, and Mitchell.
Oh, so it's probably conflict. Okay. All right. Conflict then. So likely it'll be a reset for plea and arraignment. 23 is Keon Russell in custody.
That'll be mine, Judge.
Mr. Bridges, is that you?
Yes, Your Honor.
All right. We continue with, that's the end of that one. Anyone here for a final plea and arraignment expecting to hear their name called but was not? Any follow-up announcements from either of those calendars? Mr. Heath, did you have something to add?
Yes, Your Honor. State was able to relay like a preliminary offer, but obviously they're not sure of who's going to be taking over the case. We would just request that it be re-noticed for another final plea to give us an opportunity to kind of weigh that.
Yeah.
He's got a private attorney.
Let me go back. All right, well, I think we've already noticed it for the trial calendar. We've got a calendar call on the 8th,
Okay,
and that would give you some time to keep pressing them, and we can see where we are on the 8th.
okay,
Otherwise, I don't see any pending motions, and so I think we just keep moving it forward.
okay.
All right. So we'll see you on the 8th then.
All right, great. See you on the 8th.
Take care.
Yeah, that would be a good fit here. Well, he's been in here before.
Judge, can I be excused?
We actually might have something else. Nope, you're fine. See you later. Thank you.
You're just like, oh, well, cause you know they need.
Okay. So can he even, well, he can waive him. He's here representing. All right, so we don't have to worry about that then.
1 second.
Yeah, let me turn to that. All right, then finally we have our revocation calendar. We have Jamarco Howell.
I have an offer on that if we could hold it, come back.
Got it. We have Cortez Goodman.
I'm not sure if this one's private or not, because he has a private attorney on one of the underlying cases. We could hold, I'll talk to him and see where we are.
Sounds good. Position 3 is Michael Logan, and position 4 is Johnny Peebles, which we already said we're holding on. All right, so that leaves us with Mr. King and Michael Logan. And is there someone here from the state who's going to be discussing that one? Because I think that was Mr. Jordan previously.
I doubt anybody is here
It
that
is,
would.
I guess I will be handling. But I will tell you, Judge, your CAC attorney for now, after me, like starting next week, I think, is gonna be Abigail Potter.
Okay.
That was the last update we got yesterday, so.
Abigail Potter.
It's starting. Okay, it
All
starts in
right.
January, right?
No, Marshall said.
No, we're not going on the record. We're just discussing it. Is she any good?
Yes.
Okay, all right.
So, which case,
Can I say a couple things, Judge, or we need to wait?
Is there someone from probation here that was going to be like arguing it or wanted to be heard on it? Because this has been a lengthy email exchange. And some of these technicalities, I can't say that I have any expertise on. Bottom line is, if you want to go back through the timeline, let me just make sure I understand how we got here, which is he entered a plea. At the time we knew he was planning to go back and live in Ohio. And I think because it was a Zoom plea, that's something we do regularly with the expectation that he had to complete certain paperwork to effectuate the transfer. At some point, he wasn't communicating with him or he refused to come back down to fill out the paperwork. So a bench warrant was issued and he was arrested, spent some time in custody, got back out, and then still hasn't come back to fill out this paperwork.
Judge, the paperwork issue, I would say is my fault. No, I didn't know that he wasn't, well, he didn't tell me that communication with the probation department, that they had told him to come back. So that part, I would say, I can't put on me, but the answer is yes, it's still complicated. And the reason is because the probation officer in Ohio indicated that because he was a registered sex offender, that he could not, they were denied.
Just Ohio doesn't take sex offenders, period.
Well, 2 issues. Number one, he has minor children that he has custody. But 2, and so I talked to the probation officer myself. And I said, well, if I ask the court to make an exception, will they approve it? Well, will you approve it? She told me directly, absolutely. Which I don't understand. I truly don't, but that's what she said. So I ended up recently filing a motion to change the sentence because of that part, because of the denial. I've talked to him about the paperwork. He's obviously willing to do the paperwork.
How are you asking to change the sentence?
I want to change the sentence just to make him not be a registered sex. All other conditions the same.
But I mean, it's because of the charge that he is one, right? Like the charge that he entered the plea to? You'd have to change,
Sexual battery.
you'd have to change the charge entirely to get around that.
That would be
I mean,
correct.
that's just something, there's no discretion whatsoever for.
Around it.
I mean, there
So
are
obviously,
there are
I will amend
options.
my motion, Judge. I will amend my motion. State was obviously wouldn't be ready for that. What I'm personally asking for is this court to continue this so we can do a full hearing. And then probation be heard as well. Because of the denial, they want him back here indefinitely. But as soon as he got out of jail, which was in like 2021, he moved back home to Columbus, Ohio. So he has absolutely no way that he can support himself here. He has no family. He has nothing. So I find that to be unreasonable, but at the same time, I'm hoping that there's a resolution to everything. But obviously, I don't think the state is ready to make that argument, or make the determination.
I mean, there is a process where we can transfer even folks under kind of the registry to another state. I've never heard, or I just can't imagine that that's not the case. So the question is, why has he not been able to do that? And as I understood it, it was just because he hadn't signed this paperwork. And is that something, my next question would be, is that something he has to do in person? Could he FedEx a signed copy of the paperwork to the probation officer in order to get this processed and happen and check that box?
Well, we originally didn't, Your Honor, receive the sex offender paperwork that was originally supposed to be filled out in the beginning, the polygraph form and the computer use. So they would definitely need that to register his case at all. And also Ohio basically denied it on 11/18/24, stating it was an invalid plan of supervision. They contacted his mother and his mother said she wouldn't comply with those conditions of not having minors at the household. So automatically they denied it. And then he didn't provide, he said he would move, but he didn't provide a address to probation. So
So essentially, even if it was transferred, Ohio would revoke his probation because he's not living in compliance with their requirements.
Man, this is complicated, Judge.
That's the real.
Well,
So it's not even really a problem of him needing to come down here. It's that he just doesn't want to comply with the requirements.
I know he wants to comply. My understanding is that he's confused about what he needs to do, because living with his mother, well, he would have to, I guess, move the kids somewhere which he has legal custody. Would probably satisfy one thing, but the probation officer in Ohio, I talked to her directly. She told me that I don't think we had that conversation. I asked for the exception. If this court provided an exception.
Yeah, that's just not something I can do unless the state wants to do some kind of extraordinary motion or something, but. And this was, and I remember the plea very well. I mean, it was something of a unusual case, and I think the state even recognized that in the colloquy, and but that's nothing that I have control over here. So
I would have to continue this,
We can-
everything here, allow him to do what he's supposed to do, and then get another chance for the transfer.
all right, well, again, the transfer is probably not your biggest issue, but it may be the only one that really affects us. Once it's transferred, then we can maybe at least be done with it on our end. So I guess I'll go back to the question of, to get it transferred, was it only an issue of the paperwork not being signed
it was the paperwork and his living arrangements.
and the living
And
arrangements?
because they denied it, he was supposed to come back to Georgia. And we told him to come back to Georgia on 2 occasions.
Yeah.
They also ordered him to come back today, being that they thought he would show up for today's court hearing. So we are planning to issue a warrant as it's the second time.
Yeah. Are you able to resubmit applications to Ohio if there's a new application?
I would have to check, but also we're still at the issue of, I have no sex offender special conditions at all for, it was never filled out since the
Yeah.
plea. So I would just need that as
Right.
well. But I can ask if we can resubmit it and that if they'll take it again. I don't know if that's a thing.
I'll have the electronic copy today, well, it's already signed, but yes, he's having problems submitting it. Cause I was gonna walk in with electronic copy and have them overnight the actual copy. After this conversation. But, I would
Just for the record,
We're not on the record.
Oh, okay, well, I did communicate with Mr. Jordan as we were sitting here just to get what his thoughts were when he last had it. Mr. Jordan said, short of changing the actual charge,
Right.
he was fine with whatever that would allow the probation to just continue and get everything situated. So, obviously, we would have no issue with trying to resubmit the paperwork or all of that.
Yeah. Yeah, I would just think because he already got picked up in Ohio for a good amount of time, he'd be pretty motivated just to obey their directives. But that being said, why don't we see if we can get the signature aspect of it and the paperwork figured out? And we come back in a very short amount of time, you know, have a status in like 2 weeks, or maybe even we'll see what we can add it on as a calendar, first week of January or something like that, to see if at that point probation has the signed paperwork and can resubmit the application. It's going to end up in the exact same place if he can't find living arrangements that are in compliance. So I'll just note that, but I think that's what's going to have to be done. And then, but at some point, if it just keeps dragging out, and probation, and he's not doing what his probation is directing him, then I guess he gets picked up on a warrant again.
I understand, Judge. I'll make sure that he gets this paperwork in, well, electronically today, probably Monday. I would ask that the state hold off on a warrant, but I'll be in communication to make sure they can.
All right, but I don't really see any reason why paperwork can't be, like you said, overnighted or provided to him
He already signed it, Judge, so.
within a week. I mean, probation should have that paperwork immediately and then can give us direction on resubmitting it to Ohio.
So would you like us to hold off on the warrant? Because we were gonna issue one due to him not showing up today.
Yeah. We'll renotice it. Yeah, I would hold off. We'll renotice it and it's going to be for a, you know, like I said, short time frame, only a couple of weeks.
Thank you, Judge.
All right. Take care, Mr. King.
Oh, thank you.
All right. I think we've made it through all the calendars. And so is there anything else or anyone else who had an updated announcement?
I have an updated announcement for Mr. Randall, but I'll wait for Mr. Bridges.
I mean, as far as I understood it, he's not here. So we've waived arraignment on your case and we'll further notice it and we can take up your motion whenever we can
If it may
schedule
please
it.
the court, we did reach a negotiation where he was willing to lift the judicial hold, but I don't want to speak on behalf of him, not in the room.
Okay.
I think I successfully got on Zoom.
The defendant. What's the defendant's name?
No, is she going to get Bridges? I don't have to. Oh, I did. We were gonna do an update announcement on Randall. He wasn't brought over. So the one case with Mr. Cross is waived. We have to reset the third one. And he was mentioning, do you have an additional announcement perhaps?
Your Honor, I guess we actually can't make an announcement because what we're initially, he has been accepted to a drug program, but if he's not here, we can't send him to the drug program.
Through like the entry of a plea or something, you mean?
No, not a plea. You were asking me about the judicial hold. I was gonna lift the hold and in turn allow him to go to the drug program and make addition of the bond that he remained in the drug program, but he's not here. Because he's not here.
Right. And the way he's bouncing around different counties, I don't know how we would ever get these cases moving forward until we can have him here. Now he's in Gwinnett apparently. Going from Cobb to Gwinnett. You know, so.
Ideally,
Yeah. All right, y'all can follow up through email if you want to do a consent order of some kind. For now, the case one is reset, or excuse me, position 3 is reset, position 2 is waived and further noticed.
we have a reset date.
First, well, this, are you gonna take the third position? Yours is just gonna keep moving,
Okay.
because you're waiving arraignment, right?
Yes.
Signing the indictment, and we're good. Take care.
Judge, what was the announcement on Lawrence Melrose, position 6 on the final plea? Oh, I think Mr. Marks is on Zoom maybe or something.
You should just sign saying with permission.
I think for most of these, he's wanting to talk
Oh.
with them first.
Okay.
Yeah, that was just a hold.
Judge, I have an updated announcement on position 21 on the P&A.
Okay, did Ms. Taylor step out, or is she still gonna stick with us?
No, she had to go
Oh,
back,
I was
but
gonna
she
ask her.
did give me her recommendation
I'll take
for the
permission.
other case. And I talked to her about Mr. Rhodes. She's gonna get in touch with Mr. Adams.
Is hers still kind of swallowing yours?
Well, when I told her kind of what I thought Miss Wiggins kind of portrayed as well, I think it may change something. I can't say for certain, but she said she was gonna give Mr. Adams a call because she also recognizes if that was kind of what was led on, that it may need to just stay that way. So
Okay. All right, well, we'll see that one at the calendar call. Mr. Simonov, which one did you say you had?
Number 21 on the P&A, Your Honor.
21.
Mr. Jackson, he qualifies for our services. It's gonna be my case. I'm about to get him to sign the joinder. We're gonna go ahead and enter plea of not guilty, waive formal arraignment, and ask for a case management order.
All right, Mr. Jackson, after you sign the indictment, stay in touch with your attorney and you'll be free to leave, okay? All righty.
She said, what should I?
Mr. Holland. Good talk to you, sir.
People? I mean, I've never seen him working with anybody else. Oh, like actual individuals? I think they're in custody. I have to double check. Yeah. There were a couple on here, I think. Like Chanel Lamb was on Zoom. Okay, not appearing. So we gotta reset. Okay, reset for P&A. All right. Well. Oh, well, he's talking to people.
Your Honor.
What do we
Can I
have?
make an announcement?
Of course.
So I represent Timothy Turner and he is I talked with him by Zoom. I think he's in custody in Columbus, Georgia, according to his representation. He wishes to plead guilty to the indictment and to accept the state's recommendation of 10 years probation and conditions. So what I'd like to do is, when it's convenient for everybody, to do it by Zoom. And I guess I can step in that room over there and just do it virtually. Or I could do it here.
We can just do it right here at the podium, right?
Yeah, I can do it here. I guess the only advantage of doing it there is I could have a breakout session if he wants one, but I can
Yeah.
do it right here.
All right. And well, if he asks for one, then we would send you out. How about
Okay,
that?
that works.
Which position was that again?
This would be
19.
19.
I'm gonna go get my phone.
Okay. Well, yeah, Mr. Bridges, you let me know if that would work. We can just move into that one. Yeah, position 19. But don't worry, I'll switch it to another one right before we're about to start. Okay. Yeah.
So I'm gonna leave the Zoom call, I guess. Since I'm here in person, I don't think I need to have it on Zoom or. That's not gonna create an issue.
No, I think we'll just pop them right up here and we'll be good to go.
Gonna be technical issue if you don't know how to log back on if you need to.
I don't think I need to.
Hope you don't need to.
Yeah, all right. Okay. Hello, Mr. Turner. I'm over here now.
Hello.
Hello. I'm gonna sit in this chair.
Can you hear me?
That's okay?
Yeah. Oh, she wanted the recorder.
No, I didn't put it on there. Thank you.
Ready? Let's go on the record now with 24 SC 004885, State versus Timothy Turner. Mr. Turner is joining us by Zoom. As I understand it, he is in the Muskogee County Jail. Is that accurate?
Yes, sir.
Okay. And so, Mr. Turner, and the rest of us, including your counsel of record, Mr. Marks, are here present in the courtroom. And this was scheduled for arraignment, but I've been informed that you may wish to enter a guilty plea to the indictment or that you've negotiated a resolution with the state. And so the first thing I would ask, Mr. Marks, is there any objection or concern with us proceeding in this mixed virtual capacity?
No, Your Honor.
So, Mr. Turner, at any point, if you can't understand us or you need us to repeat something or you need to speak privately with your counsel, just let us know, all right?
Yes, sir.
Mr. Bridges, if you could swear in Mr. Turner.
Mr. Turner, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Below your hand, sir. State your true and correct legal name.
Timothy Virgil Turner.
Are you at this time taking or under the influence of any alcohols or drugs?
No, sir.
Is there a medication that you normally take that you have not been given today?
Yes, I have not been given it.
What's the medication that you normally take?
It's mental health medicine, Run, and I think it's I forgot the name of it.
And does that medication affect your ability to understand the proceedings today?
No, sir.
Excuse me. How old are you and how far did you go to school?
33, and I made it 9th or 10th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you're charged in indictment number 24 SC 004885 with 1 count of aggravated assault, 1 count of aggravated assault, and 1 count of cruelty to children in 3rd degree?
Yes, sir.
You understand that you have the right to plead either guilty or not guilty to these charges. If you plead not guilty or remain silent, you may receive a jury trial.
Yes, sir.
Have you had enough time to speak with your lawyer about all facts and circumstances known to you regarding the charges of this indictment, including any potential defenses?
Yes, sir.
Do you need more time to discuss the case with your attorney?
No, sir.
Are you satisfied with his representation?
Yes, sir.
Counsel, do you waive formal reading of the indictment?
Yes.
And do you waive any all defects in the indictment?
Yes.
Mr. Turner, do you understand it's a negotiated plea, which means the state will make a recommendation? The state's current recommendation to the court will be for count one, 10 years probation, count two, 10 years probation to serve concurrent with count one, and count three, 12 months probation to serve concurrent with count one. Special conditions, anger management, no contact with the victim, stay away from the incident location, 100 hours community service, and complete your high school diploma or get a GED and stay gainfully employed. Do you understand those are the terms of the courts that the state's recommended to the court?
Yes, sir.
You understand the court does not have to accept that recommendation. The court can sentence you to the maximum. Each charge can run those sentences consecutively or one after the other.
Yes, sir.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal court.
Yes, sir.
You understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering guilty plea today.
Yes, sir.
You understand that if you are placed on probation or parole of any kind, you cannot violate any criminal laws of any governmental units or special conditions of probation without being subject to revocation for the balance of the sentence.
Yes, sir.
You understand that you're not allowed to possess, use a firearm while on probation.
Yes, sir.
Mr. Turner, are you a United States citizen?
Yes.
You understand there may be other adverse or unfavorable consequences as a result of your guilty plea conviction, just as there would be for a conviction following trial. For example, your guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or your ability to obtain employment.
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
Do you understand that you waive any all defenses, including any mental health defense, by entering a guilty plea today?
Yes, sir.
Do you understand that if you went to trial, you have the right to take trial by jury, a right to see, hear, and confront witnesses called to testify against you, the right to testify or remain silent, not incriminate yourself?
Yes, sir.
You understand that by pleading guilty, you give up the following rights: the right to a trial by jury, a right to remain silent, not incriminate yourself, a right to confront witnesses against you, the right to assistance of counsel hired by you, or court-appointed counsel if you cannot afford an attorney at trial, the right to presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, and the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if you're convicted of these charges after trial.
Yes, sir.
Has anyone forced you, threatened you, or promised you anything to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charges in indictment number 24 SC 0048885?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, sir.
You understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge and file we call a habeas corpus challenging the constitutionality of the guilty plea?
Yes, sir.
Had this matter gone to trial, the state would have shown that on January the 21st, 2023, officers responded to 787. I'm going to spell this for you: AYRSHIRE Circle, Northeast Atlanta. They met Mr. Turner. Mr. Turner was explaining to them about an altercation that happened at the residence. As the conversation continued, they talked to the victim in this case, and it turns out that Mr. Turner was a primary aggressor, and he took a wine bottle and actually hit the defendant, the victim, and also he grabbed a knife and attempted to cut the defendant, and that would have been the state's case had this matter gone through.
All right, and we've got a hand raised. And Mr. Turner, I just point out that, first of all, if you need to speak with your attorney privately, you can. But I'll just say that this is just the factual basis alleged by the state. And for the purposes of this plea, I don't think we're asking that you agree with every aspect of what they've said, but just that there is a factual basis that supports you entering a plea to this indictment. I'm going to ask the state, I presume, based on where he is, that he's not eligible for a first offender?
Yes, sir.
My client says he is.
All right, so why don't we go through that questioning, or maybe we can check him with probation.
Your Honor, he has no record of felony probation in Georgia. I don't know about anywhere else.
Okay, Mr. Bridges?
I'm checking, Your Honor. I thought I saw a felony for him. Yeah, I'm incorrect. It is not a felony. I don't see felonies. I see only misdemeanors.
All right, why don't we follow up with some questions for Mr. Turner then?
Mr. Turner, are you asking to be treated as a first offender under the provision of the First Offender Act?
Yes, sir.
Have you ever pled guilty or no contender to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, sir.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
Not that I know of.
Has your lawyer explained the First Offender Act to you?
Yes, sir.
Do you understand that if you violate the terms of the first offender sentence or commit a new offense while on first offender probation, your first offender sentence status would be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, sir.
All right, Mr. Marks, anything else I should know?
Yes, Your Honor, may it please the court. My client represents as follows. He's 33 years old, has a ninth grade education, works at a Waffle House, has one child. We'd ask that you accept these terms and sentence Mr. Turner accordingly. Thank you.
And do you know what kind of charges he has or he's dealing with in Muskogee?
What do you got going on there, Mr. Turner?
I was accused of, I think, simple battery, terrorist threat, and criminal damage to property.
All right. No, you don't have to tell me anything more, Mr. Turner. I just wanted to emphasize that whatever happens in Muskogee, you can only use first offender once. And so you're choosing to use it for this case here in Fulton County, okay?
Okay.
All right. I have a few other questions for you. Do you understand the nature of these charges?
Yes, sir.
And you still wish to waive the rights that were explained to you and go forward with this change of plea?
Yes, sir.
And are you doing that because you're guilty of these offenses?
Yes, sir.
Do you have a weapons carry license permit of any kind?
No, sir.
Mr. Marks, are you satisfied your client is competent and understanding that the plea is voluntary and that there is a sufficient factual basis?
Yes, Your Honor.
I agree, finding a sufficient factual basis and that this plea of guilty is knowingly, voluntarily, and intelligently entered. I'll accept the plea and I'll sentence you, Mr. Turner, as recommended by the parties. I note that you served 254 days here in Fulton County before you, I think, bonded out on this case. And so that's 8 months, and I'll have that reflected in this sentence. So the sentence on count 1 would be 10 years to serve 8 months with the balance on probation. Count 2 would be the same sentence to run concurrent. And count 3 would be 12 months to serve 8 months with the balance on probation. The special conditions would be that you're to complete an anger management course. You're to have no contact with the listed victim. You're not to return to the incident location. You're to complete 100 hours of community service. You're to make your best efforts to obtain your GED or high school diploma, as well as to stay gainfully employed. I'll accept your request for first offender treatment, and I'll withhold adjudication. Were you requesting automatic sealing, Mr. Marks?
Yes, Your Honor.
Any objection from the state?
No objection, Your Honor.
I'll have that implicated, indicated rather, on the final disposition, as I find your privacy interests outweigh any public concern. We'll impose a behavioral incentive date of 3 years. And for any technical violations while you're on this probation, those will be handled directly by your probation officer with a sanctions cap of PDC or RSAT. Mr. Turner, do you have any questions about anything I've said or anything we've discussed here today?
I didn't understand the last part, as far as, PD or RSL.
Sure.
And
Okay, so what that is a technical violation of probation is if you were to fail to report, for example, if you were to fail to pay certain fines or fees, and if probation were to believe that you had a violation of that, what would usually happen is they'd file a warrant, a revocation, and you'd have to wait in jail on a court date. Instead, if it's under this sentencing option system, for any of those technical violations, they can handle that directly. You don't have to wait on a court date.
okay. I have one more question.
Sure.
And ma'am, do I have to serve any time, once released from here?
No, not on as of this sentence.
Okay.
Now, whether this sentence, if you're on probation for a misdemeanor somewhere else, that's something you'd have to deal with. But as a result of this sentence and this sentence alone, there is no additional time.
Okay, and, I would like to talk to my, attorney on private.
All
Okay,
right.
that's gonna take a minute. I gotta get back on Zoom then.
Okay.
Fine.
We will go into let you go into another breakout room. If we don't resume, well, no, we'll put it on the record, whatever the results of that
Well,
are.
I guess, do you want to talk to me, before this sentence is accepted, or is this just a question about what happened?
It's just something that need to be updated. I just need you to update something.
Update something for you?
Yes.
Okay.
Do you have any concerns about the sentence that we've already announced and imposed?
No, sir.
Okay. Then with that, is there anything else I missed, Mr. Bridges?
No, yeah.
All right, we'll be off the record, and Mr. Marks is going to join you in the breakout session, but otherwise, Ms. Akuzu, do you have some reporting instructions for him?
Yes, I'm not sure when he will get out from Muskogee County, so he can report to 276 Memorial Drive, Southwest Atlanta, Georgia, 30303, 48 hours upon release.
Did you catch all that? Does she need to repeat it in front of a microphone?
She need to repeat that.
Yeah.
Okay.
You got to go to a microphone for Zoom.
Okay, so I'm not sure when you'll be released from Muskogee County. So to avoid any warrants, I'll have you report to 276 Memorial Drive, Southwest Atlanta, Georgia, 30303, within 48 hours upon release.
Okay, let me write that down for a minute.
Okay,
So what that basically means is once you get out of jail, within 2 days, you got to go to probation department here in Atlanta.
Okay.
That's what that means.
Okay, I'm trying to get the address.
do you have a phone number you would like me to send it to?
Yes, 404
Okay.
553
Okay,
5222.
and who is this to you?
This is my mother's number.
Perfect, okay, I'll text her the instructions.
Thank you so much.
You're welcome.
You still need to talk to me in private, or do you want me to call your mom instead? It's up to you.
Oh, you can call my mother instead. Thank you so much.
Okay, will do. Thank you.
All right, take care. If there's anyone in Muskogee County here operating the Zoom, we've concluded with Mr. Turner.
Thank you, Your Honor.
All right. So, any other announcements we want to take up?
Good, Mr. Williams, Philip Williams, number 9 on PNA.
Yep.
He is qualified. We're gonna go ahead and plead him not guilty. Wait for more arraignment, ask for case management. He's already signed.
Number 9 is further noticed. Mr. Williams, stay in touch with your attorney. If you've signed the indictment, you're free to leave. You'll get notice your next court date in the mail.
Thank you, Your Honor. See the bond folks or the jail folks first? What do you think?
I mean, I'm out here talking to people. You can probably talk to the jail folks.
Yeah, right. Yeah. Can I go talk to the inmates? Yeah.
All right. I'll go sit back. All right.
First floor for the clerk's office.
I'm drinking tea.
Thank you.
That's what I see.
I got something on that. Green tea.
Go ahead and go. I'm gonna agree. Yeah. I don't know about this weekend. I'll talk about it. That's not about it. But I'll talk to them. The opportunity is not terrible. Not this weekend, good, but it's not terrible, so. We'll see. Yeah. I need to talk to you. Still better. I can't. I just can't get it. I'll tell you what, you can. Oh, do you have? Yeah.
What's that? Tea? I need some water. Yeah, please. They're Vestlin.
Mm-hmm.
What about that?
There's clearly a mental health issue there.
I gotta look at discovery on.
Yeah. I think he has some other disorders.
Okay. I'll look at discovery and I'll follow competency. Cause just talking to him today, I can't.
I already know the deal here.
Yeah.
Yeah, so.
Did the pre-indictment attorney file comp, do you know?
I don't know. And there's something here that says defendant did not appear for a meeting.
I don't know what that means.
Get ahead of that. Well, cold is fine. Thank you, I appreciate it, sir.
Ooh. She did file something under seal, so they may already be
They may be
pending.
already pending.
Yeah, yeah.
This
Let me talk to them.
This is Fulton County.
Right, but it'll be easy on the process.
It's on hold. You got Ministry here, Friday, you got MLK, you have Central. The court, you got
Mitchell don't have, Mitchell's Mitchell Street. And you have this building, which is central, and you have 105 Central, is in that corner this. Then you got the old building, which is 136 Pride. Right there, then you have the Marshall, and you have, pre-trial, right at 160. So it's kind of like three buildings, you can fit all three of the buildings inside this building. Okay.
Got the key? Yeah. I forgot it. That's what I said, I pulled a macadamia thing, because I still have my key. You don't need hot tea with your call?
No, I was just getting the water.
Need hot tea.
I need hot tea.
Can't get sick, you gotta finish. So we need to beat super people out of here.
I can check Kathy and see if they've got any hot tea.
Well, we have hot tea, he's just refusing.
I'm good with the water. That's that grandbabies don't make me sick.
They always do. It's the germs.
Yeah.
I'm working on it. They may have already done. About, I don't know if they were reporting yet, so I'm gonna get in touch with that attorney.
It's cold.
To see
Yeah, but.
if she got anything that she know.
Yeah, I just wanted to
Is it
flag that
big?
because I saw that. I read the report.
She only found,
But I don't think I have.
I don't know if her report will be ready yet.
Okay.
Because 2 months is a little quick for them,
Okay.
but I'll check. I'll let the judge know.
Okay.
Thank you, though.
Okay.
Anything you need else?
Not yet.
And what are we gonna do in two bond hearings?
I'm about to go talk about that.
The lights on. Let's see if it's in this office.
Boy,
Yes,
is Deputy Scott back there?
no, is the light on?
Yeah.
I'll go see if he's in his office.
So it's. You might come black and white.
I told Boy, yeah. I moved up one.
But that's Scott, he wasn't outside.
Yours already?
No, they have the light on, we don't have them.
I can't find Jamie there. Are you talking to yourself?
I was talking to you.
There's no one else better to talk to. Than yourself. There was this lady and her mom. And she's like, Mom, are you talking to yourself? Like, I don't see anybody else better to talk. He just let us in and he stayed back. Oh. Oh.
Okay.
I'm sorry.
Yeah, that's the red.
I don't move the public defender stuff. I am gonna kind of line it up over there, though.
Hopefully we don't lose.
I forgot my other.
That's we should leave them the tables.
And it's.
Whether he's planning to do anything else until he handles us.
And it's good. Yeah. It reasonable. No, I.
Chairs.
No, I'm done. You sure? Yeah, right here. Yeah. You need.
Yeah, I don't like the.
I'm fine.
I had this computer since school.
Oh, really? Yes.
That's remember, we don't know what this is.
I think I know, so, yes.
You get a whole count.
Yeah, it's coming up.
Colson. Back with Harrison Sunday. Particular.
I use this one too. I use.
I'm gonna do a roll too.
Yeah. If. Mama. Your attorney's license. Yeah. Oh, you want to sit there? No, no, you don't. Not that side. I can bring it up with you.
I'll bring that up. Could be fun. That's one thing not having a human in the machine. Over there. One of the two.
She went back in the truck because she thought she left her phone in my.
That one didn't roll.
Oh, okay. I see the court front over.
All right.
I thought I found downstairs.
All right, before we go on the record, we have everyone here from, who needs to be here on behalf of the plaintiff?
We're all set, Your Honor.
All right, on behalf of the defendants,
Yes, Your Honor.
you ready? Oh. All right, let's go back on the record now. By my calculations, jury's been deliberating about 2 hours. We haven't had any questions. I think they worked through lunch and I've been told they have a verdict. So I'll ask Deputy Scott to bring them in and we'll see where we are.
Back to the jury.
Thank you, Deputy Scott. Members of the jury, I've been informed by Deputy Scott that you have been able to reach a verdict. And so I would ask the foreperson to identify themselves. Just tell us their jury number.
Juror 1?
Juror 1. And so have you reached a verdict?
Yes, Your Honor.
All right. And you can stay seated just for a moment here. And was it unanimous?
Yes, Your Honor.
And has this verdict been filled in, signed, and dated by you?
Yes, Your Honor.
All right. If you could hand that to Deputy Scott so that I can look at the form of the verdict. All right. And so I would ask the foreperson to publish the jury, or excuse me, publish the verdict into the record just by reading what you have found, and then you can hand that back to Deputy Scott.
We, the jury in the above referenced action find as follows. We, the jury, find in favor of the defendants.
All right. If you could hand that to Deputy Scott and counsel can inspect the form of the verdict. All right, so beginning with the plaintiff, is there any objection to the form of the verdict?
None, Your Honor.
Any from the defendants?
No, Your Honor.
Is there any reason why this jury should not be excused at this time?
No, sir.
No, sir.
All right, members of the jury, that concludes your service here this week. As always, I want to thank you for all the attention and the time you've dedicated to this. In just a moment, I'm going to excuse you to the back, and from there, you're free to gather your belongings and leave. I will try to rush back there and thank each of you individually before you do leave. And I also will offer to try and answer any questions you may have or about the process or what maybe we were doing while you weren't in the room. I know also counsel sometimes like the opportunity to be able to get your thoughts of what made an impact and what went into your decision. And if you'd like to entertain that kind of back and forth with counsel, we'll have that happen as well, but you're certainly not required to. And so as of now, the obligation you had not to discuss the case with anyone or do any research about the case or anything like that is lifted. And so it's with the thanks of this court for your service that you are excused.
I'll rise for the jury.
All right, were any counsel from either side interested in meeting with the jury if they were interested?
Categorically so. Yes.
Yes. All right.
I mean, what I would suggest, we'll just go down there past the elevator.
No, you can come on around back, actually.
Okay.
We'll just have you come into the jury room when I come talk to them. I think, as I understand it, we need to have someone prepare a proposed judgment form. And so I would ask the defendants to prepare that, provide that to Ms. Sue. And if there's any input from plaintiff before we would file that, they can provide that. Is there anything else then we need to have on the record before we adjourn for this case?
Not from our side, Your Honor. It's been our pleasure.
All right.
Your Honor. Thank you.
Then we'll consider court is adjourned. We'll let you know in just a moment.
Stop, Dick. Stop, man.
I don't know. Y'all get it, so.
We haven't formally introduced ourselves.
We never did see me.
That's Jay. Nice to
It was your fault.
Everybody else, I've never known anybody else from selfish knowledge, but I've known him for years.
Well, I am a baby, so I just like to be able to watch the process.
Good people to learn from.
Yes.
Thank
No, pleasure. Pleasure's all mine. Nice.
It's good to meet you in this case, Sydney.
Good to meet
Nice
you.
job.
Thank you.
Yeah.
Thank you.
Right.
To the next one, yeah. Good job. Good job.
Yeah. This was the latest.
None of this. Are we good?
That's how.
I got my bag over there. I'm gonna get it there.
I think it's the, at the table.
I don't want to. Yeah, but I don't want to talk to you first.
No, I'm working on it. I was trying to.
Trying to get some more endorsements on your.
No, yeah, do some more. I know.
You have real time coach.
Yeah.
I do use that.
But it's limited.
Oh, your license. Stay there. You want us to sit there?
I said, what are our computers here? Wait, yeah, I know. That's what. Yeah,
At one point, it used to be a team. Into us, but then they switched over. Oh, no. Yeah.
So let me do what they say.
Yeah. Did you have my courtroom?
Yeah, we did.
Yeah. So then, sure, but you know. It's cold.
Pleasure. See you guys.
Nice to meet you. Alright, okay. We're just waiting to see if it looks like this.
Yeah, he next time the jury. Can't move without him.
But you can see, I forgot what. Yeah. Sometimes they anyway.
Yep, 404.
It's just. This Charles can come back. You know the one that copies from the writer? There's one.
If not, you guys, I'll see you together.
If I have my microphone, I'll be sure you get.
Yeah, yeah.
It just.
Yeah, the one is. Then it's expensive. And everything is.
But let me try it.
Yeah.
Huh?
Yeah, Joe.
Yeah, cause it's got.
Uh-huh. Okay. We just stepped in, jury came back in for the civil.
Oh, okay. I'm sorry, I forgot they were still actually in a civil matter. I would have took my stuff. Okay.
I am okay, because if you need. That got your number.
Yeah.
Just flag it, I mean.
Oh, no, I'm a deputy right now.
Yeah.
This one. Oh, this one. I can save it.
Yeah.
And then put it
Yeah.
up.
I'll go back and do that.
Okay.
If you want.
I'm plugging this up, please.
Yeah, she needs him. You know what I did? When I saw the video for it, I start scanning my exhibits in, like, in meeting. Yeah, see, I have, like, unless this they already have it scanned in. Most of the time. Yeah, the scan it? I don't, yeah. Yeah. I haven't printed them. Yeah. Maybe I'm more equipment over. I mean, cause I used to do stuff like that. That is on. I don't like. Especially like say, everybody's in the courtroom now. You know, cause I can't hear. I thought it was no, the unit, I don't know the remote was close and I can. See them. But automatic button again.
That's the charges.
Let me have a copy of this. I do, just in case it.
You got, I guess you have a copy for the videos.
That one.
I was so confused. I heard Judge
I mean, I know they
like,
got this
I don't
now.
see him. Where is he?
Did you hear him play that was in his own? Yeah. He said that's the what now?
That's the video.
Oh, it's on.
You good.
Okay. Y'all know what you got. I don't even have one. I missed his reason to pack on. Getting lost. What you do? I get them for these guys, you know. And I do have a box, but it's for the office. I'm gonna see if I can find a box. I might go 2 trips. I'm not gonna carry on. It's so far. Oh, what, yeah. I know what you're charging for. Go there, market. One of those stuff. Oh, I can go there. No, I'm on. I forget, I can go and see. All right. Thank you.
I think she's trying to get you self.
I think I found somebody, but that's okay. I found something. Hi, Mr. Lawson.
This is, I don't have any more.
You can put some in here,
But see, you might have to, it's just,
yeah, I found some, I'm gonna take this anyway.
yeah.
I'm gonna have to just keep it.
I have to bring me some more.
I don't know what to do with that. What's your clock? Close. Different than. Oh. I have it on me.